My certificate of SC has been terminated ex parte without giving me any notice. I even not communicated over the WhatsApp. I came to know on 4th. Maybe on Tuesday, your lordship.
Please, Tuesday.
At the top.
Yes, sir.
Grateful. What is
He's senior to you, but he's not mentioning.
The Dental Council, Miller, is going to hold a meeting by the registrar, through Registrar Miller. The registrar is acting upon a
Dental Council.
Dental Council, Miller. Miller, registrar is relying on a notice, Miller, election notice, which has already.
What do you want? Upgradation?
Miller, no. I seek leave. Want to move, Miller. The meeting is going to be held today, Monday, Miller, at the top.
Definitely. Yes. Leave is granted. Monday top.
Lordship, may I mention a matter for upgradation, Lordship? It's 752 of the item number, Lordship. It's a new motion matter, Lordship. Lordship, petitioner preferred the RTI application before the SPIO. Thereafter, being agreed by the order by SPIO, he preferred the first appellate authority. Thereafter, subsequently
taken an upgrade matter. Please give us.
Yes,
sir.
Yes. One company matters related to near about 2,000 crore misappropriation. SFIO investigation. First time appearing in the other court, I am praying for time. On that particular date, kindly see the order.
You are for whom?
SFIO. As if I am consenting, that's why this order has been passed. Kindly let it be appear as a to be mentioned. That's why I could not, investigate in this case.
You took time to take instructions.
Only I am praying for time, but this order has.
Yes. No, you prayed for time.
Kindly see the
this is not a ground of urgency.
Consenting part. I am consenting, my lord.
Consent has not been recorded.
Yes, my lord. Kindly see the last four lines.
Learned counsel appearing for a 6 time to take instructions. Yes. Counsel submits that no. Oh, achha. You must have submitted.
Yes, my lord. I don't say anything. I don't say.
Upgraded either. This will appear under the upgrade headings.
Get.
Please ask your learned junior to give us.
Yes, yes.
Thank you. Yes, Mr. Channel.
The item number 30.
30.
Of course, this has upgraded. But facing urgency, my lord.
Every day I'm trying to take up matters. So let me.
May I I normally do not, your lordship.
No further mentioning.
Extreme urgent.
No further mentioning. Call on the list.
Matter would render tender.
Call on
tender matter.
No further.
For judgment, item number 1.
For the petitioner, man.
Sorry, dismissed on contest. Yes.
For judgment, item number 2.
In such view of the matter, WPA 24556 of 2023 is allowed on contest, setting aside the impugned communication dated September 27, 2023, and directing the CA, the competent authority, to reconsider its opinion, advice in the light of the observations made above, and to issue a fresh advice to the learned special officer for him to proceed with the preparation of the electoral roll and with the process of election itself. Fresh advice shall be issued by the CA within a fortnight from the date of communication of this order.
Deeply obliged, my lord.
Top item, item number 3.
Yes.
Lord, I appear for the petition.
Short passover.
Let him start. Yes.
Lord, your lordships have not gone through the matters earlier also. Just for your lordships recollection, I'll just take 2 minutes to give you lordships the background.
Please. Yes.
Lord, Central Warehousing Corporation and FCI. Lord, they are the two respondents. Lord, Central Warehousing Corporation, CWC, they have godowns. FCI send their goods there. It is kept there. FCI takes it on rent. And Lord, then for handling, Lord, Central Warehousing Corporation, Lord, floats tender and Lord appoints tenderer like us, Lord. We send a bill through CWC to FCI. So it's not that the CWC pays us, FCI pays us, but the bill is generated through CWC. CWC above our bill charges 8% service charges. Now, the job was done by my father. He expired. There was no complaint with the job. After he expires, I approached for the remaining bill amount. Initially, they said you bring a succession certificate. I submitted that. Then they said raised some issues of a criminal proceeding being going on where my father was not a party, not an accused. Not your lordships, not why your lordships. Initial order dated, but I'll give your lordships the date of the order, has ruled out that and said that that cannot be a fetter in releasing the money. Then, my lord, when the matter was initially taken up by my lord Justice Mousumi Bhattacharya, Lord, the Central Warehousing Corporation made a submission that they cannot pay because since FCI has not paid them. Lord, thereafter we filed an application saying that FCI has cleared our bills. Despite that, CWC is not paying us. Your lordships, my lord, white order dated July 26. Lord, my lord need not take the trouble to find it out. I am reading it. However, insofar as the clarification which is due to come from FCI is concerned, CWC is justified in making such submission. The submission that was made by CWC that let FCI disclose how much money they have paid in what account, then we can disclose it. Lord, FCI has filed 3 reports before your lordships. Lord, kindly take the first report of FCI and the third report of FCI. First report, Lord, affirmed on, I tell you, lordships, Lord, this is affirmed on 22nd August 2023.
Yes.
My lord, kindly takes that.
The first report.
That's the first report. 22nd August, my lord, it is affirmed by one
Got it.
Dipankar Tiwari. My lord, kindly take the exception filed by CWC. My lord, affirmed perhaps on 29th of August. My lord, yes,
Exception
29th.
was given on the last occasion. They took time to file exception.
Yes,
Yes,
they
my
have
lord, served with us.
they have filed exception against 2 reports, first and third. They
Oh,
have filed a comprehensive. Lord, what I'm trying, Lord, to sort out the papers so that not I can refer those papers. But kindly take out the first exception, 29th August, affirmed by Devapati Saha Chaudhuri. But should I find out those documents for your lordship? First report, first exception, third report, third exception. Only these 2 documents are required.
Yes, exception I've got. Only one exception has been filed.
Yes, the other one, they wanted to file it
They
today.
took time but have
Not-
not yet filed. Yes.
Lord, I have a copy.
Devapati Shah Chaudhary I've got. Yes.
Then kindly take the trouble to find out the third report for a second, Lord, that FCI, your lordship directed. Lord, the
Here, brother.
third report is affirmed on 29th September.
অর্ডারের তলায় কিছু ঢোকাবে না জানো অরিত্র অর্ডারের তলায় কিছু ঢোকাবে না অর্ডারগুলো very well. The first report, first exception I've found.
Yes, third report affirmed on 29th September by FCI. This is affirmed by Angshuman Das.
Now I've got Vinoy Kumar. Anyway, this is something. What was the date again, Mr. Chakraborty? You said?
Not 29th September.
এটা বার করে দাও 29
আমাকে দিন না, আমি এক্ষুনি খুঁজে দিচ্ছি একবার দিন। Need out for your lordship.
29 September, please find out. Yes.
উপরে একটা সিল থাকবে এরকম।
29 September is the second report.
Third report.
Third report.
Second report was absolutely, Lord, inconclusive. So, Lord, your lordship wanted them to file a third report. So, I'm not referring to the second report. Third report.
Supplementary report, third report.
And Lord, I will only refer to one page of the writ petition, page 193. Only one page of the writ petition. And the exception that they have filed against the third report, Mr. Chaudhary is not here, Samrat Chaudhary, but I have a copy, I'll refer it to them. But kindly take the trouble to come to 193 for a second, Lord. Just to show my claim to your lordship.
Yeah.
Not take the second box.
Hmm.
This is with regard to Kharagpur. Lord, I have raised a claim with regard to security deposit of 43 lakhs, supervision charges of 38 lakhs 81,000. Now, what is that? What they have done, admittedly, CWC charges supervision of 8% above my bill and send it to FCI. FCI clears my bill, their supervision charges, they receive my money, they send it to me. FCI for some reason did not pay them the supervision charges which they are entitled. So what they did, they deducted that money from my account and kept it with them instead of raising a claim with FCI. Second, now the third claim is bill amount of 61,55,000. Now it appears that FCI has paid 61,63,000. Now height withheld, another head. There's a dispute with regard to height withheld. I'll come. Invoice of DC Jhargram, and these are not small amounts. The first three amount not is very important. 43 lakhs, 38 lakhs, and 61 lakhs. Now, with regard to this, you will also call for the first report. Not kindly take the first report now.
Please take your seat. Yes, take your seat.
দেখিয়ে দিয়ে সব ক্লিয়ার হয়ে গেছে তোমরা রিপোর্ট দেওয়ার
You have paid your money, so need not stay.
Yes, not today. I believe there is no dispute at all.
If you did not pay the money, you might have.
No, my love, you have released the money. Only thing, we may not be saddled with some other thing. That is why I'm a little concerned.
We may always be saddled with anything. We cannot guarantee. Court cannot
Well,
guarantee. Yes.
Now take page 5 of the report, first report.
5.
Yes. Lord, kindly allow me to place from the last paragraph of page 5. In case FCI hires godown from CWC directly, godown rents for space hired is being paid as per the ministry approved rates. Apart from that, handling and transportation contract is being appointed by CWC through open tender following the rules and regulation of both organizations. The work of HNTC is to transport stocks from unloading point, railway siding specified to the godown and stacking, destacking, etc. Following the terms and conditions specified in the tender document as per the procedure in vogue, the bills raised by HNTC to CWC, being the employer of HNTC, preferably on monthly basis, are being scrutinized at CWC, and CWC submits the bill to FCI for reimbursement to them. CWC also raised another bill with 8% supervision charges on the whole HNT bill amount of FCI. FCI then, after statutory deduction, reimburse pay the bills of CWC, not the HNTC, in case of non-following of any instructions in the overall operations conducted by CWC for storing the FCI stocks through their appointed HNTC. FCI deducts corresponding amount from the bill which are duly informed to CWC. Any dispute raises in between being resolved through meetings between the two organizations at different levels from time to time. However, it is not in the liability of FCI to inform all the details of payments and deductions made from the bills to HNTC, and CWC, being the employer of the HNTC, it is their duty to justify the payments released to them by them to HNTC. Hence, payment of HNTC bills by CWC to the contractor in no way related to non-payment of any HNTC bills and supervision charges by FCI to CWC for one reason or another, as far as the same are justified or under examination, reconciliation between the organization through laid down procedures. CWC should take the whole liability in case of non-settlement of any amount. So, but one thing is clear, my bills is separate from the supervision charges. If it is not paid by FCI to them, they can raise a separate claim. But that is not related to my bills. What they have done, they have not received, they have deducted from me. But kindly now see the box. Security money for CWC, 43,28,000. Security deposit being deposited by the HNTC to CWC, being a contract obligation between them and FCI. But here FCI has nothing to do. I have shown your lordship page 59 of the writ petition, where says, my lord, that your lordship have also recorded in the earlier order that security deposit cannot be withheld. What they are asking for is, they are asking for that I should give a no claim certificate. Then only security shall be released. Now, if I give a no claim, I lose on the supervision charges and on my bill. Your lordship said that my lord will decide the entire issue. Since they have no other claim, so security deposit cannot be withheld. This is number one. Now, with regard to Lord, kindly, I will beseech your lordships to keep the skip point number 2 for a second. Kindly come to point number 3. Point number 3, that is my bill amount. 61,55,000. Kindly see what FCI says. Amount of rupees 55, 88, 84, 259 and 579 has been paid to CWC Kharagpur during 1st February 22 to 15th February 22 and 16th February 22 to 18th February 22 respectively, to the tune of 16,63,000, which has already been informed to FCI White Swan Show contract to the petitioner mother Srimati Sunita Agarwal in respect of the RTI reply. With this reply, my lord, I filed that can, my lord, when they made the submission before Justice Mousumi Bhattacharya, that they have not received the money. So, my lord, it is clear that all my bills amount are cleared by FCI. It is lying with them. Now, my lord, kindly take the pen to come back to 2. Now, with regard to the withholding of supervision charges, kindly see what FCI says. Supervision charges are already mentioned above. 8% supervision charge are claimed by CWC on the whole HNTC billed amount for their supervision on the operation done during transportation, storage, maintenance of stocks.
Supervision is between FCI and CWC.
Yes, I have got nothing to do. Stocks, as such, this amount is not a direct claim of HNTC to CWC. Then, however, it is to inform that the said amount for the corresponding month were not released to CWC due to lapses on supervision made by CWC. Lord, kindly pause here for a moment. The next line created a confusion in the mind of the court. Court asked for the second report. Due to reduction in the H&T bill amount which were claimed beyond specified operations, which results in reduction in corresponding supervision charges. What happened is, with regard to height, Lord, now it appears that they have not rejected my bill of 13 lakhs. That is where it is mentioned. That is got nothing to do with the supervision charges. Lord, in my humble submission, CWC at best could have lost 8% on the bill which is rejected by not making payment to me. 13,93,000 height withheld bill, which FCI has now says that they have not paid to on my account. So supervision charge corresponding, perhaps they have not also received.
But the second portion of 2 is also pertaining to the supervision charges, corresponding to the reduction. But it deals with the supervision charges, which corresponds with the reduction.
Absolutely. I'm grateful to you. So this amount, since they have deducted from me, they have not received it from SCI, they have a separate claim, they could raise it.
Your total bill is 6,55,000, 61,55,000.
61,000 is the bill amount which is pending. 43 is the security deposit which is lying with them, and 33 which they have illegally deducted from my earlier bills, since they have not received supervision charges.
Very good.
Now,
so they have to pay you 4328 for 400 and this 6155
and 3881 which they have illegally deducted.
Very yes.
Now kindly come back to point number 4. Next page.
Yes, 4.
Height withheld 13,93,572. The bill raised by CWC or its H&T do not commensurate with the operations conducted by CWC through its HNTC during stacking of bags in different layers as per the existing norms, as objected by FCI Divisional Manager Midnapur, who highlighted that matter during his inspection of godown. The reason for such difference also informed to CWC. Hence, in no way FCI is liable to pay the amount to CWC for which false claim was made by them. But kindly mark the next sentence. It also results in reduction of corresponding supervision charge of 1,11,000, which I was referring. So if my bill is not paid, they are also not getting 1,11,000, which is charged above my bill, because that entire bill is cancelled for August 21, which is also included in the claim in serial number 2. What they have done is, I have not received any money. My bill is rejected, but their supervision charge they deducted from me. Now, with regard to the point number 5, that is a claim of 5,62,000. FCI says FCI has got nothing to do, because those were other service providers like the state government organizations. I am not troubling your lordship with those for the present. Kindly take the exception taken by CWC.
Chakravarti, before going to that, 2, please clarify again. I am not clear on that.
I'm so sorry.
Item 2.
Item 2, Lord,
The
is
second portion.
second portion.
Please clarify that again. I am not clear on that.
I'm so sorry, Lord. The supervision charges, CWC 8% they included in my bill. Now, for the corresponding month, kindly see
Your bill has nothing to do with supervision charges.
No, absolutely not.
You don't supervise, so you did not charge for
Absolutely not.
They have, CWC takes 8% supervision charge, 8% on the bill.
On the bill. Over my bill, they raise a separate bill. Now, they
has
have
been withheld from there. But 38, 81, 330, the entire amount has been withheld
from my earlier bills. But what happens is, not,
Yes.
may I explain it to your lordships?
Yes.
Not suppose for the month of January, I raise a bill of not 10 lakhs. Now they charge 8% on that 10 lakhs. It comes to 80,000. Suppose CWC does, FCI doesn't pay that 80,000 to them. What they do is they pay me 9 lakh 20. FCI sends 10 lakh in my name. They keep 80,000. In any way, they have to keep their money. But they should raise a separate claim against the FCI. They cannot deduct. This way, 38
Even if
lakh.
the FCI does not pay them that 8%, they have to pay you your entire amount.
Absolutely.
Very well.
And
Yes.
that's admitted from their reply also.
Please come to the second part of 2. That is where
Second part of 2, due to reduction. Malad is referring to that.
however, it is
However,
informed.
However, it is to inform that the said amount for the corresponding month were not released to the CWC due to lapses on the supervision made by CWC. Now, this should have been one single sentence because this corresponds to the earlier portion of the block. That created the and created a
Disjunct.
disjunct.
And then due to
And due to reduction in H&T bill, this refers to my height bill 13 lakhs 93,000 amount which were claimed beyond specified operation, which results in reduction of corresponding supervision charges. Now read this along with lot 4. Read this along with the last line. It also results in reduction of corresponding 8%. 1 lakh 11.
they reduced, that's why.
They reduced.
CWC reduced.
And
For that has not been paid to them, the
Yes.
corresponding.
Lord, say, Lord, today I have a bill of rupees 1 crore.
Suppose today this 13 lakh something, this height charge is paid to you, then FCI has to pay them that 8%
1 lakh
on that.
11,000. Lord, FCI may not even pay them. Sometimes due to lack of supervision, FCI may not pay them.
That is different.
That is but if they pay, they are entitled. But they cannot not take from me. They are not getting from their employer. That means they cannot take it from their employee.
2 and 4 we can read together.
Yes, we
Second
have-
part and 4 we can read together.
We have to read together. Not that created
This
confusion.
1,11,486. This 8% supervision charges. This relates to
That
the last
13
portion
lakh,
of 2.
13 lakh 93,000.
Very good. Then their
Kindly
exception now.
take their exception.
Yes.
That
First exception.
29th August exception.
Yes.
But I'll show you lots one by one. Lord, kindly come to internal page 3 first, Lord, of the exception. Let us kindly got it, Lord. Internal page 3. 3A. With regard to the disbursement of security deposit for the Central Warehousing Corporation, named so-and-so, clause 7 of paragraph 9, under caption security deposit of the e-tender document for appointment of regular H&T contractor, dated so-and-so, being appended to the writ petition at page 33 thereof, read with provisions appearing at serial number 2 to paragraph 4 under the caption process captivity of the document titled settlement of security to H&T contractor for all food grain warehouse. The deponent craves leave to this honorable court to produce and refer. Thus, in view of the aforesaid provisions, the answering respondent had issued correspondence to the writ petitioner on 29 July, which was respect to WPA number so-and-so. Also being the writ petition in the aforesaid writ petition about compliance of the aforesaid conditions as prerequisite for the purpose of disbursement of security deposit. Thus, the petitioner is aware of the necessary document required for disbursement for the security deposit. Answering respondent still awaiting. But kindly come to A. What they say about security. They want me to fill up this form. Kindly have a look at it at page 8. What they are saying that pursuant to the solemn order, your lordship decided 2 writ petitions. That is your lordship's order which is being referred. What they are asking for? No claim demand certificate from the concerned handling transport contractor for the concerned contract period in terms of 9(7) of the tender document. Lord, this is not possible for me to give, because if I give that, then I lose on my bill and the amount that they have illegally withheld. No due certificate from the contract warehouse manager where the H&T has provided services. Lord, this is to be given by them, their warehouse, their manager. 3. No due certificate from the concerned depositor. Lord, here the depositor is FCI. That is before your lordships. No due certificate from the concerned authority designated under the Employees Provident Fund and Miscellaneous Act, reflecting due to correct deposit in terms of, Lord, NOC we have already submitted. That's my instructions. Then 5, an indemnity affidavit from HNTC, that also we have submitted. So, Lord, they were asking for a no claim, which I could not. So, Lord, with regard to security, they don't say that they won't pay. They are asking for a no claim. But that, Lord, I think answers the point. Now, kindly take B. what they are saying with regard to supervision, very interesting. With regard to amount 3881, only towards supervision charges in respect of the monthly bill of February 20, March 20, April 20, August 21, January 22. The same is admittedly withheld by FCI. So FCI withheld your claim, you withhold from my bill. You cannot do that.
No, you have claimed this amount from CWC.
Because they have illegally withheld it from my earlier bills. Lord, I could have in
FCI adjusted this amount with the 8% security interest.
FCI has not done anything. FCI has not paid them their charges. What they have done is they have
Amount is same.
yes,
FCI
amount is same. Amount is same. Lord, what is being done is from several bills, FCI did not pay them the security deposit charges, service charges. What they are doing when they are getting the payment without the service charges, they are deducting the service charges, keeping that money with them, paying me the rest of the amount.
You are asking for this 38, 81, 330 for what? What have you done?
That is, I have not done anything. That
Your
is,
previous bills.
if they have withheld from my previous bill on the
They have nothing to do with this security supervision.
no,
Supervision FCI does, CWC does.
CWC does.
So that is what I am asking you. So these bills have nothing to do with supervision
No,
from your end.
no,
You
no.
are asking for your previous bills,
Yes.
but FCI has withheld that amount.
And they are saying
It
that
under the head of supervision charge is 8%.
and that is why they are saying we will not pay. Now come to C. With regard to bill dated February 1st February to 18th February, it appears that Food Corporation India alleges of payment 61,55,000 only. However, the said Food Corporation of India by the letter dated 2nd March has deducted rupees 13,19,540 only, thereby realizing the same for and on account of railway road transit loss for the period during the terms of the deceased father of the writ petitioner, a photocopy of the letter dated 2nd March 2022. But what happens is, Lord, this reminds me of we read a story in our childhood that Lord, that the goat and the tiger was above the hill.
Stream.
Yes, he says you have not done it, your father has done it. So FCI, whatever amounts is deducted by FCI, they are saying I am liable to pay. Kindly come to B, page 9. On what ground FCI has deducted from them? It is to inform that this office has received an enhanced rent bill. Enhanced rent bill. Rent bill is rent for the godown. That is CWC charges on FCI. CWC Nimpura for the with effect from April 19, February 22, amounting to 2675 after deduction of income tax and recovery of 1319 for enhancement bill of CWC. So and so amount comes to 10,88,000. Now kindly take next page. Why it was deducted? Recovery notice. This office is in receipt of your reply by letter dated so and so to the notice issued regarding JV report finding 1.42% incurred in rice rake X RIG to KKQ and RR number so and so. Kindly take the next paragraph. However, your reply is not satisfactory, convincing about the various anomalies pointed out by the JV team, such as mismatch between peripheral counting of stacks and census declaration provided by CWC. Weighbridge installed by CWC Nimpura found to be faulty with wide weight variation observed during test payment. But I have got nothing to do with regard to that. Even for the first, I have got nothing to do. Lack of proper accounting and loss of grains and spillings, due to which the said RTL could not be established on the part of the consignor. Accordingly, in view of the above various anomalies, lapses and misappropriation of stock,
So what about this proper accounting of loose grain spillage?
Lord, that is the supervision charges. Supervision.
Why not the transporter and handler has to look into it?
For that, CWC has to inform me, issue a notice, issue a proceeding, initiate.
Has been done.
Nothing. They are not also saying that anything is done. They are saying FCI did not pay me. I am also taking it out of you. Lord, they are trying to establish their claim in my writ petition, which perhaps they would not be allowed to do. And kindly see the last line, lies CW so and so, and total loss value of 13,93,000 lies upon CWC, and the same will be recovered from your bills. Lord, I have got no relation directly with FCI. I am appointed by CWC. FCI pays me. It's a 3-stage procedure.
Yes, yes.
So, my lord, here, admittedly, FCI paid 61,55,000. They are saying since FCI has deducted some bill from their account, so they will withhold that amount.
Let us come to the third report.
Yes, kindly, that is internal page 4. I was there. My lord, one more document I have to show.
Yes.
Internal page 4, I was there. I was reading it.
4.
For internal page 5, but I referred to, then the next paragraph I will just place. It is pertinent to mention that the communication of the letters dated 28th February, 2nd March was not required to be served upon the writ petitioner since the HNT contractor for the relevant period being the deceased father already died. It is also pertinent to mention that the deduction of 13,19,000 was due to transit loss, which is entirely due to the declaration on the part of HNTC. Now, can you take D? With regard to the amount of 1393, now that's the claim 4 of page, not first report, claim 4, that height withheld. Can you see what they're saying? Only on account of height withheld, the same also appears to be withheld by the Food Corporation of India. In this regard, provisions containing the clause 3 under the caption services of the e-tender document is relevant inasmuch as any deduction made by the depositor on account of improper stacking shall be the sole absolute liability of HNT contractor. Therefore, the deduction on account of height withheld is entirely contributory to the HNTC. Now, E, with regard to the amount payable on account of casual labor, Lord, the 6th column of my claim received, answering respondent has received 2 bills for the month of January 22 and February 22, total amounting to 1,58,000. Only thus question of claiming 3 lakhs doesn't arise. It is pertinent to mention that the claim of 1,58,000 can be entertained by answering. Let them pay that. Lord, if my lord tallies it with page 7 of the first report, page 7 of the first report, report of FCI,
Yes.
column number 6, casual labor charge 3 lakhs. CWC says they will pay me 1,58,000. Let them pay that.
Subject to your producing this GST paper.
Yes, we'll do that.
Yeah.
We'll do that. So, my lord, with regard to the claims that we have made, first security deposit is admitted, supervision charge admittedly not paid, bill amount admittedly not paid, height withheld. With regard to height withheld, the third report was called for by your lordships. But kindly see the third report for a second now.
Not only height withheld, probably 2 also. The second part.
Yes, that they have explained. Not I have explained to your lordship, now they have also explained. Kindly take the third report. Exception ta কোর্টের কাছে নেই, দিয়ে দাও না, তাহলে I can refer it to them. But if Mr. Chaudhary submits that exception, I can also refer it side by side. Not
Yes, yes, definitely.
Now take page 5 of the third report. Page 5
Of this report.
of the third report.
Yes.
This is a letter, Lord, issued by Lord FCI to Mr. Barman. Lord. Kindly allow me to place from in this regard. The HNT bill for the month of August 21 raised by CWC do not commensurate with the operations conducted by CWC during stacking of bags in different layers as per the existing norms, as per the circular guideline, headquarters New Delhi. On receipt of the payment vis-a-vis recovery details of FCI, on 1st October 21, CWC through letter dated 13 November 21 had informed that the height of stacks was maintained accordingly as per the declaration of breakups given in the worksheets and requested to release the withheld amount. Accordingly, FCI, by letter dated 25th November 2021, had requested to CWC to verify the number of bags mentioned against C and D heights and to submit the revised bill, rectified bill for verification at the FCI end and taking subsequent action regarding the settlement of the release withheld amount of 13,93,000 in reply to the said letter of 25/11/2021. CWC by letter dated 10 December 21 had given stack-wise details, wherein it was found that in each stack formed in the godown during the month of August 21, bags in B 11 to 16 height layer, C 16 to 20 height layer, D above 20 layers. Since same number of bags in each layer B, C and D in each stock is quite unnatural and it is not physically possible to keep same bags in B, C and D layers in almost 322 stacks that formed in the month of August 21. In this regard, FCI by letter dated 15 December had once again informed the discrepancy in the bills and requested CWC to submit and rectify revised bill for early settlement of the pending withheld amount of 13,93. However, till date, CWC have not submitted any reply to the letter dated 15 December, and hence it can be assumed that CWC has agreed upon the withheld made by FCI on an amount of inflated bills of H&T. Then the next paragraph in this regard, it is pertinent to mention that forwarding of the bills through which CWC claims H&T bills along supervision charges, the amount of H&T bills has been found mentioned under the column amount be paid to contractor, which implies that CWC has already paid to the H&T bills amount to the contractor, which is confusing in nature since the petitioner has applied for the said withheld amount. There, I may say that the amount withheld curtailed to the inflated bills of August 21 by H&T and certified subsequently CWC 13,93,000.
So they castigate you also.
They have not paid my bill, 13,93,000. Not
They
kind,
said you have a role to play also. Your bills are
But-
inflated.
but what happens is this stacking, as I have understood from my
You
client.
also have a role to play in stacking.
Absolutely.
Bring and stack.
Now, the more I stack, perhaps not subject to correction by my learned friend, that the spaces would be utilized more if I maintain a proper height and all that. Then I can, perhaps this is an incentive given to me. If I maintain a proper stack plot and height maintained, then I can raise a bill amount that. They said their bills are unnatural because all the stacks cannot be same. So they have rejected my bill. Lord, today, upon instruction, I'm saying to your lordships, 13,93,000, my lord need not adjudicate today. FCI has not paid me, I will initiate proceeding against FCI. But that cannot be a ground that CWC would not pay me other amount. Now kindly see what the CWC has said in their reply. Not only two paragraphs I will refer, para 8 and 9. Internal page 9.
Yes.
Thus, in view of the aforesaid provision, it is apparent that unless the withheld deducted amount of 13,93,000 only is disbursed by the Food Corporation of India, the central warehousing is unable to disburse the same. But I accept it. Today, the picture is clear that they have not paid me. Earlier, I did not know because FCI says they did not inform me. CWC did not inform me. I raised the claim in the writ petition. FCI says they have not paid me. I will raise separate claim against FCI. Or if my lord adjudicates upon exchange of affidavit, I am not inviting your lordships for the present. Apart from this 13,93,000, the entire amount is admitted and there is no defense put forward by CWC of not paying those amount. Security deposit they cannot withhold. 38,83,000, which is supervision charge not paid by FCI to CWC. Admittedly, CWC should raise a separate claim against FCI that you have not paid my supervision charges. They cannot take it away from their employee. Now, with regard to bill, admittedly paid by FCI. Now, for some amount of 13,93,000, which FCI did not pay them, they are trying to take it out of my pocket, which they cannot do. They can obviously do by initiating a proceeding, but they have not done it. That's not the report. And with regard to the fifth claim, they have not said anything of 5,62,000. If my lord takes the first report, page 7. First report, page 7.
Yes.
In the exception also, CWC has not dealt with, not subject to correction by Mr. Chaudhary. Nothing has been said about this 5,62,000. Because if my lord comes to page 6 of the first reply, then they have directly come to after the height withheld to the 3 lakh amount. 5,62,000 has not been dealt with by them.
And casual labor, they want to pay a
As
part
well,
of the
they
amount.
want to pay 1,58,000.
You are agreeable to furnish the GST and get that amount for the time.
Absolutely. But I don't want to get into any disputed claim right now. Whatever is admitted, I want to take that and run my business.
What about the 61,55,723?
Not,
Supervision.
that's the bill, not supervision. That's the bill.
Right.
Not column number 3, you'll also be referring. That's the bill.
There's the addition. There's a sum of 48 and 30. Not that.
Not 61 is my bill. For the
43 security money Oh, acha, 38 is previous bill.
Previous bills, and 61 is the bill, not from February 22 to April.
Right.
Not kindly come to internal page 7 of the,
I'm there, yes.
not kindly see column number 3. It's from 1st February to 18th February, 61. And kindly come back to column number 2 for a second. Kindly see the date, February 20, March 20, August 21. So it has got nothing to do of bill of 2022.
Right. Right.
But am I being able to make myself clear, my lord? Previous bill, present bill. Everything is paid. Let them release my money.
First, I'll hear the CW.
Yes, ma'am.
Because they are the main. You have made your stand more or less clear,
Yes,
unless the CWC raises some other. Yes, Mr. Chaudhary, what is your?
My lord, firstly, if my learned friend gives up the claim of 13 lakhs, I will not press that. In the writ proceedings.
Gives up means he'll claim it separately.
Yes.
I will not direct you to pay. In the writ
if
proceedings.
he agrees to that, then I will not press the height
Don't.
the height part. Now, my lord, as far as the second column is I'll start from the beginning. The security deposit. Now, on the previous occasion, my friend said that this is not part of the e-tender document. The lordship kindly takes up page 58 of the writ petition.
Yes.
Not 33.
Yes, Mr. Chaudhary, please argue.
My lord, page 58. If
Yes,
your
I'm
lordship
there.
kindly comes to page 59.
Yes.
This is the clause 7. The security deposit shall be refunded to the contractor only after due and satisfactory performance of the services and on completion of all the obligations by the contractor under the terms and contract and on submission of a no demand certificate. Now, my lord, what is this no demand certificate? I ask myself. Now, here, my lord, there is a bit of, I believe, something which has not been explained. That is, the contractor is not my employee. He's a contractor under me, my lord. I provide him with the necessary instructions as this has to be done, this has to be done, this has to be done. Now, that work has to be supervised by the contractor himself because the contractor employs casual laborers. Laborers are who are performing. He has to maintain a supervision on that. I shall show that from the e-tender document itself. And what is to be done is instructed by me. How it is to be done has to be done by him. Now, this no demand certificate has to be provided by the depositor. That is the one his predecessor was serving. Now, my lord, the writ petition has been filed by the son of the contractor. So the son cannot say what has been done, what has not been done, because he had not performed the job, neither he had instructed the casual labor to do the job. So we have to rely upon a part of what the Food Corporation says, because Food Corporation from
The entire work was done by the father.
Yes, entire work was done by the father.
He has taken up the job now. As a
He has not taken up the job also.
He's only on the claims.
He is only on the claims. So he cannot say what he did, how he performed. That he cannot say, that he cannot have personal knowledge of. Now, if your lordship kindly sees, this no demand certificate is actually a certificate which has to be provided by the depositor. Now, what is the necessity of this certificate? I will not ask a certificate just like that. The necessity is, as far as the depositors are concerned.
Depositor means the contractor.
No,
the depositor who
depositor means whose
FCI
commodity,
here.
yes, whose commodity has been stacked there.
Yes.
The reason why we want this is because if there are any complaints or if there is any short of performance which has been identified by the depositor, then he will have a claim. Claim in the sense that the depositor will not disburse the entire amount. Once that is done, well, we receive that certificate, we have no difficulty disbursing, because then it.
So that has to be given by the FCI.
That has to be given by the FCI.
All right.
How it helps us is by not once the depositor gives us the no demand certificate to them. We, if any claim is not paid by the Food Corporation of India, we can lodge a claim against them. So we indemnify the contractor. It is not at the peril of the contractor. It is to the benefit.
Now, in the present occasion, what is your ground of withholding that?
One of the Food Corporation has not given that no demand certificate. It cannot give because it has claims. I shall show the claims that the claims are asserted, assignable to the.
Has the no demand certificate been explained anywhere in your terms?
Well, that is there is
Is
it
it
is
defined
it
anywhere?
is not being explained. My lord, there is a.
From a plain reading, it has to be given by the contractor.
My lord, my lord, it is.
It cannot
been,
be that I won't pay you if somebody
my
third
lord,
person doesn't give a
that
note.
has been disclosed in the exception to the report. That is on record.
No, it has to be evident from the contract itself.
Your lordship kindly takes up
No
the
demand,
letter.
no demand certificate has been used anywhere else in the contract. I don't find it. It's like your client won't pay your fees if the judge does not give a no demand certificate.
No, man. That has been explained in the letter
I mean,
which
why?
is developed upon.
How can they be dependent on a third party?
No,
If you have some specific allegation against them,
my lord.
then you are always at liberty to take out a proceeding against them.
Correct.
Departmental
My lord,
inquiry, they are proceeding
my
against
lord,
them with.
we can have a complaint.
But the remission, the disbursal of their security deposit cannot be dependent on third persons.
I tell you, lordship,
Issue.
why?
No.
I tell you, lordship, why? Why it is so? Because tomorrow, my lord, let us say there was a short of performance. The food corporation, in this case, the depositor, has withheld some amount. Now, I cannot pay them unless until it has been withheld by them. But once this no demand certificate
You
is
cannot
granted by the
blackmail the
depositor,
contractor for that. It may be your latches also.
it
If
may
it's a
be.
contractor's latches, then you can
My
take
lord,
out a
absolutely. But here, my lord, the food corporation depositor is here. The short of performance has been clearly stated in the report.
maybe. This no demand certificate cannot be attributed to the depositor. It's not reflected anywhere in the.
If your lordship,
Anyway, let us continue with the next.
and if your lordship kindly takes up,
Yes.
takes up the letter, which is annexure A to by exception to the first report.
Yes.
Point number 3.
Yes.
No due certificate from the concerned depositor in order to ascertain my claim, liability, deductions, or any dues pending for the concerned period to be recovered from the concerned agencies. It has been clarified. We have told them what is.
Mr. Chaudhary, you have to eat your own words probably because see 1 and 3 together.
I understand, but I understand. I understand. I have taken instruction from the officer, my lord, officer in the court. This no due demand certificate is to be provided by the depositor.
Your one says no claim stroke demand certificate from the concerned handling and transport
Yes,
of
my lord.
contract.
In terms of the clause 7, I am placing clause 7. I'm relying upon
So
clause
you
7.
are saying that has to be given by the handling and transport the transport contractor.
No, my lord.
One says that. Your letter says that. Read it out. What are you saying? Read one.
No claim demand certificate from the concerned.
That is the language is no demand certificate from
Yes,
the
my lord,
H&T.
it is from the contractor. The contractor is to obtain it from the depositor.
Ridiculous, Mr. Chaudhary.
My lord, that is
Ridiculous. If your officer has said that, I'll have to say he has to hear that this is ridiculous. What is the next point?
My lord, this is as far as the security deposit is concerned. So we are awaiting that no demand certificate. As far
No
as the
demand,
second-
you have to have it for a long time, probably. Till the appeal court sits as
My lord,
in my order.
my lord, I am.
But what about the other points,
I
Mr.
have
Chaudhary?
just
Let us
narrated
proceed.
the procedure to your lordship, but I have not gone into the reasoning as to why it is so or how it is so. I have just
Procedure
narrated
is not even clear from your contract. It is not there in your contract. No, I'm
It is
sorry.
not there. It is not there, my
It is
lord.
not there in your contract.
No, my lord. It is not there in the
So
contract.
your
There is a-
explanation or your officer's explanation won't do.
My lord, there is also a standard of procedure which also says that. But since it is not on record, I will not rely upon
Anyway,
it.
next.
There is an SOP.
Next. SOP says what? We have to give you that chance. SOP says what? Explains that no demand has to be given by the
Contractor.
by
By
the
the depositor.
show me that.
My lord, it commences from serial number 1 onwards. It should be.
Can I mark this?
My lord.
Can I mark this?
Yes, yes.
এটা ফেরত দাও ওনাকে। Please read it out for all of us, Mr. Chaudhary.
I know, my lord, will correlate
No,
that
read
with
it out. We have to hear it.
no demand, no claim demand certificate from the concerned HNT contractor for concerned contract period. I know, my lord, this
So it's
goes-
not there in the SAP also.
May I? No, no, no. That's the no demand from the contractor. You can demand নিয়ম আছে।
হ্যাঁ, ওটা তো কন্ট্রাক্টর
CWC
হ্যাঁ, CWC আর এখানে একটা ওয়্যারহাউস ম্যানেজার আছে। আর কি আছে না?
ঠিক হয়ে যাচ্ছে।
বলছি ডিপোজিট আছে।
ডিপোজিট আলাদা। এইটা যিনি ডিপোজিটে গিয়েছেন আপনাকে তো
হ্যাঁ, আমাকে সেটা।
my lord, I rest my point. I rest my argument. My lord, with regard to this, I was aware that it is from the
Let
deposit.
him argue the law, you argue the facts. Mr. Chaudhary, please, this is not your fault. Please let us continue. Let us go on to the next point. No difficulty.
Much.
This is not a I mean, battle between us.
No.
So please go on to the next point.
Well,
May I
because
take a lot
this was
of
what
for
is-
a minute? May I take a-
At your own peril. Yes, you may leave, but at your own peril.
Mr. Mondal
Yes,
will
yes.
take note, not unless come.
Yes, Mr. Chaudhary, please
I
continue.
say very candidly, my lord, that was what I was made
No,
to
no, very well.
understand.
I understand. I'm not elaborating on that.
My lord, as far as 38 lakhs 81,330 is concerned, my lord, this is on account of, I read from the report which is submitted, supervision charge. Now, my lord, as my learned friend said, this is that 8% on the amount.
Mr. Chaudhary, let us just be precise on these points so
Fine.
that it's easier for
Fine.
both of us.
Fine.
Now, please come to page 193 of the writ petition once. We'll chalk out the claims and we'll decide on what to do on each of the claims.
My lord,
You'll make your arguments definitely, but let us pinpoint the issues here. Page 193 of that. Now, the only thing is the Kharagpur head is the only thing which you
Yes,
have.
my lord, it is under
Very good.
consideration.
Now, the first amount is 43,28,400.
400.
Now, this is regarding the security deposit.
Security deposit.
This you are saying that regarding that no claim certificate. Acha, very. This is one. The second one is past dues for these periods 38, 81, 330.
Right.
Now, do you want to link this with the non-payment by FCI on the count of 8%? Because FCI first report that says against this amount that this is supervision charges, 8% supervision charges as claimed by CWC on the operations done. So they say this is not a direct claim of HNTC to CWC. Now this they say the 8% has been withheld in the first report, page 6. So even if they have withheld that 8%, Mr. Chaudhary, and please don't get demoralized by the previous thing. Just argue to your heart's length. I mean, now this regarding this, that 8% explain to me, if you can, how can that 8% be an interdict for you to release the rest of the amount? I mean, their dues you cannot withhold. Your 8% has been withheld by FCI, you have to claim that from FCI. But for that, how do you withhold the entire amount?
Tell your lordship, this 8% is
Hmm.
assigned for the purpose of road transit loss.
You are linking this to the road
Yes,
transit
yes,
loss.
my lord. Now, as what is road transit loss and how I am not liable to
Yes.
any deductions on that account is
Mhm.
explained, and if your lordship kindly takes up.
As we will come back to that. What about 61, 55, 723 regarding this? The third one.
Heard, my lord.
Just
yes.
keep in your mind 38, 81, that is road transit loss.
Yes.
We'll come back to that.
My lord.
The next item at page 193, 61, 55, 723.
My lord, this is something I was also a little bit
I don't think there is any proper explanation for this because the FCI washes its hands probably. It says it has paid more than that, 61, 63 something. Page 7 of their first report.
Right.
Unless you link back everything to road transit loss, Mr. Chaudhary.
no, not all. Not all.
So they say at page 7 of the first report that they have paid you 61, 63, 303, which has already been informed.
My lord, if your lordship kindly takes up my exception,
Yes.
page 4.
First exception,
Yes, my lord. First
page 4.
exception,
Yes,
page 4.
yes.
It is paragraph C.
See,
With regards to bill dated 1st February 2022 to so and so is it appears the food corporation.
yes, you are actually linking this also to road transit loss.
My lord, because
So this is linked to road transit lot. Yes. How is 3881 330 linked to road transit loss as well? I think there's a mistake on your part on that
Your
because we
lordship,
have to come back to page
lordship
6,
kindly takes up page 79 of the writ petition.
79.
79 of the writ petition.
Very good. Yes.
Point E, paragraph E.
Yes. Paragraph E. Yes, he will be responsible. You have never raised any claim. For the first time after this claim is made, CWC is saying that this is your defense actually.
Hmm.
No, nothing, no intimation to them, nothing, no hearing given to them.
Well, as
Can
far
you
as
withhold like you don't have a lien on them?
I have taken instruction. Actually, there was no show cause or any sort of
Nothing.
was given
If
to
it
them.
was, it would be disclosed in your exception, obviously.
Yes, madam. That has not been done. That I have taken instruction on. As far as the spillage and other things are concerned, my lord, if your lordship
If you have a claim, Mr. Chaudhary, definitely you can always make that claim against them and recover that amount or whatever. But you don't have a lien over the dues.
but I tell your lordship, the difficulty would be that if I assign these reasons and try to claim it from the heir of the contractor, then my lord, that would be difficult.
The same,
because I
if
tell
he's
your lordship why.
entitled to the dues as the heir, he's also liable for paying the.
I tell your lordship, the
You
defense.
don't have any handle to recover.
I bow down to your lordship, but probably the defense that would be taken by the heir, and I'm pitballing because if I
What
at
would be
all,
the defense? Yes, Mr.
the defense they would be taking is that I had not performed the contract, and my lord, since I had not performed under the contract, any shortage which is assignable, because then it would be my lord deciding only in my favor. Because whatever I say, the court has to believe me, because there'll be no one to contradict on facts as to whether these short performances were at all performed or not performed, short performed.
No, that will be decided by evidence. I mean, that can always
That
be
is
decided.
the difficulty, perhaps, my lord.
So
Because
that
I
is
tell you-
regarding this, which amount?
I tell your lordship why these are there is because as far as the height is concerned, I tell your lordship the difficulty which was not possibly instructed by my learned friend's client was what is this height? How it is done? It is like
Height of
stacking.
the stacks.
No, my lord. That is what I also was under the impression.
What-
This is
what
the height
is
of the
that?
stack. It is not so.
Okay.
It is like there will be 3 layers or 4 layers of stacking. Now let us assume that the first layer, the base layer, since it can have maximum stability, that would fetch a lower amount of tariff. So as it goes up, the tariff decreases.
So the tariff is paid on the
Tariff increases.
balancing. The balancing.
Yes, that is how it is done. Now, my lord, if let's say,
What are you saying,
I,
Mr. Chaudhary?
yes, my lord, that is how it is
The
done.
person who can balance better,
I am,
he'll
my lord,
cannot. Mr.
my lord,
Chaudhary, this is a ridiculous thing.
that is, my lord,
Your
how it
officer is new to his job.
Now, my lord, as far as claim
Your
is
officer is
concerned,
new to his job.
now, my lord, tomorrow if I seek a refund,
Don't
now,
have him sacked in the process. What are you submitting?
my lord, this is what
If
instruction I have.
this person handler can, I mean, balance well physically, then he'll get more money.
I tell you the reason why is because, my lord, as it goes up, the amount of
Which is more money.
it fetches more money is because it is difficult to put it on top. So, my lord, the casual labor has to be compensated for the work it does. That is the reasoning of how the height is. Now, my lord, let us assume tomorrow I lodge a claim against the writ
For
petition.
that, the laborer who is doing that, he has to be paid more.
That is how they are paid. That is how it is that assessed. That is the yardstick. Now, tomorrow, my lord, if I lodge a claim, now who will? I ask myself, my lord, who will come and say how high it was and how it was measured? Because I say FCI says that it is not possible. The report that has been given by them as to how they have stacked it, which I had forwarded to the Food Corporation of India, they say it is practically
I'm
not
telling you,
possible.
Mr. Chaudhary, they raised this bill on 2nd of September 2022. Till date, there has been no show cause to them, nothing.
No, man. That I
So
admit.
now,
That I
as a
admit.
defense, for the first time, you cannot take this ground.
I
even.
admit that there is no show.
You can take that ground. This does not show bona fides on your part. On that.
Mm.
So 4328,400 security money. You have got a very weak case. 3881 and
6155.
6155, both you are linking to that road transit loss.
Low transit loss as well as the loss of spillage and other things, my lord, that is also the responsibility of the contractor. That is also a part of the e-tender document.
And 3 lakh out of that you are agreeable to pay.
That
part
we
of
are
that.
agreeable to pay if the shows are
Entire 3 lakh.
No, not entire 3 lakh. But
1 lakh something
yes,
you
yes.
said.
That upon showing the GST certificate, we'll release that. And as far as the fifth one is concerned, my lord, that is with regard to the depositor, where state of West Bengal is one of the depositors.
Which one?
point number 5, that is why it has not been dealt in my exception. Point number 5 to the my lord, table which is in the first report of the Food Corporation of India,
Acha, yes.
page 7.
So that you are agreeable to pay.
My lord, that we are not aware because state of West Bengal is not
What
party
state
here.
of West Bengal? That is a component of the bill raised to you.
Yes, my lord. These invoices of Jhargram, this is where the depository is the state of West Bengal. So unless until the state of West Bengal has lost any claim, they have made this deduction. They have not given clarification why this deduction is made by them. Exactly
You are to
as,
pay these people.
my lord,
State
the
of West Bengal has deducted. You have not even claimed that.
my lord, the state of West Bengal has to pay me to enable me to pay them.
You have not taken the defense even that they have not paid to you.
My lord, that is because state of West Bengal is not before your lordship.
So what? They have claimed this amount from you. There is no defense on your part to this. They have done the work. They have raised an invoice.
My lord, may I take it?
Just civil supplies.
Deduction.
Deduction, the payment.
এটা ওরা deduction করেছে, state.
এটা bill amount আছে
এটা হচ্ছে টোটাল বিল অ্যামাউন্ট
ওদের, হ্যাঁ,
এটা আমরা পেয়ে গেছি state of TSK
এটা আমাকে অ্যাকাউন্টস
সেটা তো আমি বলছি, সেটা পেয়েছি এখনো।
না, আমাকে অ্যাকাউন্টস
মানে this amount possibly we have not received.
He's an engineer by profession.
Uh,
Are
no,
they engineers?
not engineer. Yeah, that is a difference.
So very well. So 28,000. You have got a very weak defense. 562, no defense. 38 and 61, these two heads you are linking to transit loss. I'll have to
Transit
think on that.
Transit loss. My lord.
Because FCI has also indicated that spillage and all those things have been indicated by FCI. How
Lord-
far you can withhold their amount on that? That we'll have to think. I'll have to think.
My lord, for that purpose, if your lordship kindly takes up page 84. Page 86.
Of
Page
the
86 of the writ petition. This is the e-tender document. My lord, these are the services that will be that ought to be provided by the HNT contractor.
Yes.
Here, my lord, as far as point number 3 is concerned, this is where that height thing is mentioned, my lord. So spillage, as far as the maintenance of the height, all these are, my lord, entire liability of the HNT contractor. If your lordship kindly comes to page 91, one thing I want to place on record, my lord.
Yes, please. Yes.
Physical verification
Right.
as to who is to ascertain whether there is performance, non-performance. Your lordship takes up the clause number 11. The
Yes.
contractor shall, with their labor and scales and under their supervision, weigh such number of bags of food grains as may be required for physical verification. Their supervision. So here, my lord, the supervision which is complained of by the writ petitioner is that I have to instruct. If that can be perhaps, my lord, be synonym to supervision, I do not know. But what I have to do is I have to instruct that it has to be. I tell you, lordship, it's a very big warehouse. Now, which place is to be allocated, where it is to be kept, that is what we supervise. The security of it, that is what our supervision is. But actual physical supervision of whether it has been stacked properly, how it is stacked, how it's to be maintained, whether if there's a spillage of the food grains, how it is to be taken care of, that entire supervision is done by the HNT contractor.
Good.
The next clause is standardization. My lord, this is also in light of the physical verification as to how the services have to be carried out by the HNT contractor.
This obviously has to be done by them.
Yes, my lord. This is what I'm linking with
So
that.
they may have a role in the spillage and those things.
Yes, my lord.
Yes, yes.
The
that is,
only back foot that I am on is that I have not issued any show cause or neither have I
Yes.
made any proceeding.
but still you may have a claim on that.
Yes, my.
There is a scope of you having a claim on.
Yes, this has to be decided by whether it was so or not.
And in your exception, how have you dealt with this 6155? Let me see about that.
6155.
Because in the report,
68, it is at page 3.
But 61, you have the FCA has not linked this with anything. They have said they have paid the entire amount to you. So 6155, how can you withhold on that? Yes,
But-
you are right on the other aspect. This 38,000 and odd. But that also, Mr. Chaudhuri, even if you have a claim against them, I mean, how can you withhold? This is on past bills.
No, I don't.
So they have already done that work. So you cannot withhold previous dues on the basis of their spillage and all these things.
That is what I said, my lord. I'm on a back foot because I have not initiated any
Yes,
proceedings.
during the relevant point of time, you did not.
I did not.
Even today, you have not. But
No.
during the relevant point, definitely not.
Now, my lord, it would have been bad, much worse, because then it would be as if I'm trying to escape. So that the relevant point of time, my lord, there was no proceedings initiated.
So spillage can only be referred to 38,000 and odd. No, 38,000 and odd is not that.
This is my lord point C.
4328, you may say that regarding spillage, you have a case.
My lord.
Yes, what is the amount you have admitted out of that 3 lakh or 30 lakh casual labor?
Casual labor I have admitted 158.
Just give me the page number of your exception, Mr. Chaudhary.
My lord, internal page 6, para E. With regard to the amount payable to the on account of casual labor, the answering respondent has received 2 bills from so my lord, amounting to 158 only, and thus the question of claim can only be entered in 158.
Right.
823.
I'll direct affidavits. I'll direct you immediately to release this security money. Should I do that or dispose of the writ petition, keep the rest of the amount open for being? But regarding the rest of the amount, Mr. Chaudhary, I have to direct you to pay because you have not raised any claim even regarding the rest of the amount.
My lord, if I may suggest,
Yes.
your lordship, the report, the exceptions which are on record, my lord, nothing better will come in an affidavit.
I was wondering that.
Nothing better will come, because this will be, my lord, again reiterated, perhaps with more words.
Exactly. I mean, it will be a wastage of time
It will be.
from all
It will
for
be.
all parties. Obviously for the petitioner, but also for you. So the disputed question, I'm making it very clear. 4328, I'm not. No, sorry, 3881, I'm not convinced on your case.
My lord.
6155 also no, because they have already paid you this amount. So these two they will get. 4328, you have got a case. I'll have to think about that. 5 lakh 62, there is no defense on your part. 3 lakh, Mr. Chaudhary, 1 lakh 58.
My lord, one more thing that just has been
Yes,
informed.
yes, absolutely.
13 lakhs out of this 61 lakh 55, this has been deducted on account of job which was done by the previous contractor.
Which one?
My lord, this is that 61 lakh 55,000.
Yes.
My lord, here 13 lakh and odd was deducted on account of, my lord, which
13
was,
lakh and odd is that is on the height withheld.
yes, my lord.
They are not pressing that now. He's confusing between 13 lakh and 61.
The 61 lakh 65.
61 পরে আবার পরের বিলে কেটে নিচ্ছে আমাদের সুরচার্জ বিল থেকে
My lord, out of this 61 lakh 55, it has been released, but out of this 13 lakh 19,540, this has been again deducted from subsequent bills. Assigning this, but I tell you, lordship, here the 61 55 723, this has been paid. This has been paid. This has been paid.
No, no.
Yes, we have received it. We have
They
received.
have received.
No.
You have, yes.
I have received. I have
They
received.
have paid more, in fact, they have said.
Yes, ma'am.
But
On subsequent bills that were presented, my lord, 13 lakh 19,540 has been deducted, showing that this ought to have been deducted from 61.
I don't get your point.
My lord, 61 555, that had been released in our favor. We are custodian of that. Now the Food Corporation of India has deducted 13,19,540, saying that this amount that we had released 61, from there this 13 lakh and odd should have been deducted. So they have deducted it from,
That has not come on record in any of your
I know
exceptions.
that is, it is there. If your lordship kindly reads this one.
Hard exception.
Yes, my lord.
Yes.
Page 4, first exception itself. However, the said Food Corporation of India, while letter dated 2nd March 22, has deducted 13,19,540, only realizing the same for and on account of railway and road transit loss for the period during the terms of the deceased father of the writ petitioner. Copy of the letter is there on record. Annexure B.
No, that was regarding some other bill.
No, the period is same. This is annexure B, page 9. The recovery of 13,19,540, total road loss, so and so, finance bill of so and so, so and so, so and so, so and so. But this is
This
for
is on a separate count. Enhanced rent bill of CWC. No. Don't look at him. I'll close arguments. Hard learned counsel for the parties. Pushed up. Next para. Since the documents already on record comprise of the total papers which the parties seek to produce, comma, as ascertained from learned counsel for the parties, comma, no further direction for affidavits is being made. Pushed up. It is, comma, however, comma, deemed that none of the allegations made in the writ petition are admitted by any of the respondents. Pushed up. The further exception filed by the CWC today be kept on record. Pushed up. Arguments are concluded and the matter is reserved for judgment. I'll think over the modality. 48,000, I mean. Anyway.
that is what my instruction was.
So you try to level.
As for the heights are concerned, my lord, only for some other discussion. How the tax has to be arranged, my lord?
Yes.
The lowest tax would be more, so that the people, my lord, the labor
Obviously,
can-
obviously.
It is,
It is to be
it is
arranged,
the
my lord.
volume.
That is the way it should be arranged, but
Yes.
they are paid more for the highest tax.
Yes,
Yes,
because
that is how it
maybe
has.
the labor is more to reach to the top person. But
Acha, fair
how it is arranged?
I'll
it
not go into
cannot
that.
be, my lord, in
Maybe.
a
The
triangle.
volume of the base is more, however, the tariff is low.
But it can
But
never be
as it
same
goes
in
up,
the highest.
the volume is
It
since
is
it is
risky
less.
also probably. They have to
Yes,
go up
yes,
and down.
yes.
Maybe.
But this stack cannot be same, my lord. With the lower stack and the upper
How
stack
can
can
the-
never be same.
No.
That is why it deducted on the height. But nevertheless, that was not the issue before you.
Initially, my lord, even I was under the impression that it is the reservation of the height. But-
Yes. I also thought so.
Extremely good, my lord.
Thank you very much.
Grateful, lordship.
Item 4. I am applying for the petition in this matter, my lord.
Yes. What is the matter, please?
Kindly see my lordship's order, paragraph 6 and 7, page number 2.
My lord was pleased to direct the district magistrate to cause an inquiry regarding the plot in question, my lord, which they allege that their lands, my lord, that the PWD excavated the earth. Accordingly, my lord, the inquiry has conducted. As the petitioner has not given the land schedule in the writ petition, my lord, it is a large, vast area with the moves are concerned.
Hmm.
The inquiry, my lord, conducted by the BLRO with the help of the, my lord, the others. But it is not completed, I have not concluded. Therefore, I will request, my lord, some chance. Although I am filing my report, my lord.
It appears that I've got a copy today.
Oh,
It
yeah,
appears.
It's the original.
I've got a copy, my lord. I've looked into, my lord. It appears that, my lord, the paragraph, my lord, next page, paragraph 4.
Yes.
That is some hearing should.
The land schedule has not been given in the.
No, that is there. That is there.
So they have to produce their deeds.
Yes, everything has been
They
done.
have to produce their deeds.
Everything
Those
has
will
been-
have the schedule.
No, every,
Yes.
Lands are acquired by the PWD, the land acquisition authority, but by the for the purpose of the PWD.
no, it appears
No,
from.
no. You have to only ascertain, Mr. Vasu, whether they produce their deeds. From
No.
their schedules, the person has to ascertain whether that has been any excavation is going on those.
It will be restricted to only 15. Who? They are petitioners.
Only the writ petitioners, yes.
Petitioners.
Cannot go beyond the writ petitioners. How can it be?
Well, then it will be.
It
No, no, I cannot direct all cultivators' properties. I mean, although that would be the best thing to do.
Which time to conclude and file.
Which time means
And
after
then
vacation.
conclude, my lord.
So take this. I'll give you 1 more week, Mr. Eta ফেরত দিত। File a comprehensive.
Kept in record, I have also.
What will be the meaning of this then?
Ye-
Nothing. Learned counsel for the state seeks to file a report. However, it is submitted that the schedules of all the lands were not available with the district magistrate, for which a comprehensive report could not be prepared. In view of such submission, there will be no use of taking the report sought to be filed today on record. The concerned district magistrate is directed to have a comprehensive report, if necessary, through the concerned block land and land reforms officer.
My lord, I am praying.
Well, all they appear, all they were present. Only the problem is that to ascertain.
To direct the petitioners to assist with the.
No, everything has
next
been
para.
done. Everything has
For
been done.
such purpose, an inspection stroke inquiry shall be held at the concerned locale. Give me the date and time. I'll fix it from here. Give me the date and
But
time.
they will be given the notice to the people.
Upon prior notice to the petitioners, whose of the petitioners shall attend such inquiry stroke inspection at the notified time and date and produce all their title deeds for the purpose of ascertaining whether their plots have been encroached by the PWD for the purpose of doing excavation work. Next para. For holding such inquiry, the matter is adjourned till December 21, 2023, when it will be listed fairly at the top of the upgraded matters list. A report shall be filed on the said date with an advance copy to the petitioners, indicating the outcome of such inquiry stroke inspection. 21st, fairly at the top of the upgraded matters list.
Item 5.
For the state, your lordship.
Appearing for the petition.
Yes, Mr. Pal. What is the matter?
Lordship, we have served the private respondents. Lordship, I am challenging the order of the appellate authority. The allegation was that the petitioner occupied highway land, Lordship, and so initial inquiry was made. And first authority has passed the order. We have challenged that. Your Lordship directed us to move before the appellate authority, move before the appellate authority. And this is the third time I am moving against the order of the appellate authority. First two occasions that has been rejected, set aside as there is no reason, Lordship. Lordship, the first order, Lordship, the subdivision official passed initial order, Lordship, page 94. Copy to the.
Yes.
Lordship, that is a little bit illegible, Lordship. Can you take it?
Thank
you. Before that, there was several leave petition was there, Lordship.
Right.
Private respondent in the WP number such and such of 218 present. Should learned advocate during hearing, learned advocate stated that the case is not maintained in the court as 1. The southern part of the plot number 632, 538 are along with the state highway, but the eastern part of the plot number 538 are not state highway. Out of 17 private respondents, Lordship, I am not traveling, Lordship. These two plot was subject matter. And Lordship, the observation, Lordship. The representative of the PWD remained present and commented that they have nothing to do at. In considering above, the court hereby directs the assistant engineer PWD contrary to take up to be state to remove the encroachers where the encroachment has been made over the government land along the road and to submit a compliance report before the court immediately. Lordship, that is 632 and 538 plot number, Lordship.
Yes.
Lordship, I have challenged, Lordship. I am relying the second order, Lordship. Page 36, 136, order of the appellate authority, Lordship, I have challenged, and your Lordship has passed that order. 136, Lordship, kindly
Yes.
turn, Lordship, 137.
Right.
Third para. It is prima facie seen from the order impugned that the specific details of the encroached land have not been mentioned in the said order, nor has it been ascertained as to what is the status of petitioners in respect of the land in question. Moreover, it does not appear that either of the forums below return any findings specifically on the question as to whether the land is a government land or not. Lordship, 3 points are there.
Yes.
Specific details were not there.
Details of the land, status of petitioners, and government
Lordship.
landlord.
Lordship, thereafter, another reason order passed, Lordship, and we have challenged that. Page 151.
P21.
P20, 151, Lordship.
151 is another High Court order.
Order, Lordship.
Yes, yes.
Before that, the authority has passed the order, Lordship. I am cutting short the matter, Lordship. Because
So Justice Ghosh also set aside.
Lordship,
Private response.
Lordship. Why, Lordship? Because the reason that the order passed by your Lordship was not followed while passing the impugned order at that time. So set aside that order and remain back to the authority for passing a fresh order. Lordship, 152. It is
157, Justice Ghosh has observed that. What you said
initially
just
interim order was that
157, Justice Ghosh
Lordship.
finds that direction observation of was not followed.
That is why.
Very good.
And Lordship, thereafter, they have issued notice. And
Again, another order.
Lordship, before that, going to the order, Lordship, 172, the report filed by the BL and LRO.
These were being remanded by us to the appellate authority or the first
Appellate authority. This is the order challenging appellate authority. Lordship, this is the report of the concerned BL and LRO.
No, we had sent back to the appellate authority.
Appellate authority.
Page 172, yes.
Lordship, this is the report. Lordship, kindly
Yes.
report, Lordship. First, plot number is important, Lordship. Plot
Right.
number 537 in Mauja, Uttar Tajpur, jail number 251. First,
Plot number
537.
537, yes, yes.
Lordship, next, second, the table has been given of plot number 43
By 861.
by 861 in the Mauja, Mollikpur.
Where do I get that? 43.
2, English 2.
Oh,
both-
it's very illegible. Yes,
Lordship.
43 I found.
43.
And Lordship, page 137, 73, Lordship,
Yes,
details of 537.
right.
And Lordship, kindly turn Roman 5. Another plot has been mentioned. Second line, Government West Bengal having plot number 17296858 in Mauja, Tajpur.
This is
Uttar
where? Item number?
Roman 5,
Roman 5.
Roman 5.
bottom.
173.
173, Roman 5,
Acha, yes.
bottom.
Right, right, right.
1729. So 3 plot numbers in the report, Lordship.
Hmm.
One is 537, and one is second is 43, and third is 1729.
Right.
And Lordship, this report was submitted on 13th March 2023.
Hmm.
Last page.
Yes.
Lordship, kindly turn, Lordship, page 167. This is the communication of the additional district magistrate. Dated 15/5/2023, after receiving that report
Yes.
to the block land and land reform officer who has inspected that. In response to the memo number such and such dated such and you have submitted report regarding encroachment on government land bearing plot number 43 Mauja Mollikpur and plot number 537 Mauja Uttar Tajpur, but the report on point number 4 is not proper. The respondent number 10 in WPA number such and such has alleged that BL and LRO Agri 2 has submitted report on the aforesaid 2 plots, but measuring was done against another 2 government plots wherein encroachment exists and in front of his right land. So you are directed to submit fresh report considering all the government plots in front of the Rayati land measuring number 632 Mouja Mollikpur and 538 Mouja Uttar Tajpur, considering the respondent number 410 such and such in respect of point number 4 measuring such and such. So he was directed to cause fresh inspection. Lordship, nothing has been done. As per
This
my
additional district magistrate is the
no,
person
Lordship,
who decides?
district magistrate is the appellate authority.
Right.
This is the communication.
What was the jurisdiction of the additional?
I don't know, Lordship, but additional district magistrate has issued this notice.
Very well.
I think that was submitted before him. It is revealed from the record also that in response to your memo number such and such, you have
Yes,
submitted
exactly,
report.
Exactly.
That means this is the protocol. They have to submit the report to the additional, and thereafter, Lordship, kindly turn the order passed by the DM. And DM has passed the order on the basis of report submitted on 13th March 2023.
So that faulty report.
Lordship, that is faulty report. And Lordship, another thing is there. Lordship, kindly turn third para. They could not point out any defects on discrepancy in respect of field inquiry conducted by BLRO EGDA 2 according to the field inquiry report submitted by BLRO EGDA 2. Encroachment exists on 4 government plots, out of which 3 plots bearing number 43, 862 Mouja number such and such, and 1066. Lordship, that is neither in the report of the BLRO. Wherefrom he has got it? BLRO report has mentioned 3 plot, Lordship. 43, 537 and 1729. And plot number 1066 nowhere mentioned. Of Mouja such and such and bearing number 537 and pass the order for eviction, Lordship.
So regarding 1066, I can understand, yes, it was not mentioned.
Lordship.
But the other plots are mentioned.
Lordship, other 2 plots mentioned.
Although that point remains, the additional district magistrate.
Lordship, and Lordship has directed to give detailed report. What is the position of the petitioner? Where is the government land? Lordship, calculated the names of the encroachers and the amount of encroachment by each encroachment is clearly noted and deprecated on land sketch maps such and such. I therefore don't find any cause and reason to interfere with the order dated 6/11/19 passed by SDO. Lordship, SDO order was plot number 632, 538. He has upheld the order wherein plot number 632 and 538 mentioned. Not here in 538, nowhere 538, not 632. He has upheld that order. That order speaks about 632 and 538. Lordship, I have given the fresh copy. And Lordship, on
so 1066 is an entirely new plot.
New plot.
It doesn't even find place in the first part.
And Lordship, on last part, on considering the above facts and observation and inquiry report, BLRO regular underside being the collector directs the assistant engineer PWD Central to take appropriate step for removal of the encroachment made over government plot number such and such 431066 Mouja Tajpur jail number ato in all counts within 15 days. That the subdivision officer contact directed to necessary steps. Lordship, where is the
what about 632?
Nothing.
Plot number 632 was a part of the. So that goes out.
But upheld that order.
Yes.
And Lordship, where is that finding? Your Lordship has directed 3 things.
Those are also not there.
This is my case, Lordship.
Yes, what do you say?
Your Lordship, first of all, Your Lordship, the submissions made herein are piecemeal, Your Lordship.
Why?
Your Lordship will kindly see there are severe suppression of facts, Your Lordship. Your Lordship, the petitioner has indicated the order passed by Honorable Justice Shubhra Ghosh. Thereafter, the report, inspection taken in and report dated March 2023. Thereafter, the page 167 has also been indicated, Your Lordship. But what was not indicated is, after this order was passed, a fresh inquiry was conducted. Notice was given to all the parties and inquiry was conducted in presence of all the parties. Your Lordship will kindly come to 168. This is the notice of fresh inquiry which was held on 30th May 2023.
Yes. What happened?
Thereafter, secondly, after the inspection, a report was prepared on 3rd June 2023.
Right.
13 June. Thereafter, a clarification was sought from the department. A clarification report was also filed by the BLLRO on 7th August 2023. Your Lordship, thereafter, a date of hearing was fixed, notice was given, and hearing was held on 11/10/2023. Your Lordship, the notice has been annexed to the writ petition
The
171.
report has not been.
But
report
the
and
order
clarification-
passed in the hearing has not been annexed. Your Lordship, I shall hand over the order.
Yes.
Your Lordship, thereafter, on 11/10, Your Lordship, a specific pleading was taken by the party petitioner that a copy has not, report copy has not been served upon us. Thereafter, the court, the magistrate directed, Your Lordship kindly takes the page 3. The learned advocate on behalf of the petitioner contends that petitioners were present during the inquiry, but he is not in a position to plead the case as the fresh inquiry report along with sketch map was not handed over to the petitioner. Considering the fact and argument adduced during hearing, it is ordered to hand over a copy of the fresh inquiry along with the sketch report which was handed over by the DM on the same date. Your Lordship, that has been recorded in the order impugned. Your Lordship will kindly come to page 178. The first line, the BLLO had submitted details report regarding encroachment of the government land, and the said report was handed over to both parties on 11/10/2023. Your Lordship, thereafter, they had the opportunity to raise an objection against the report, which was served upon them. They refused to raise an objection
So this
against.
takes care of the first point raised by Mr. Pal, that regarding the inquiry report, a new report was sought. You say it was there. Two other points are there. We'll continue in 10 minutes. Two other points he has raised also, discrepancy of plot numbers. Yes, please.
Lordship, to answer the other two questions,
Yes.
Your Lordship, first I shall take your Lordship, if your Lordship kindly sees page 62, the initial complaint which was lodged before the authorities. Page 62.
Yes.
Your Lordship, from this letter, it will be evident that plot number 632 and plot number 538 are jointly owned by the petitioners and the respondents. And apparently, there is a civil suit pending over this plot. Your Lordship, thereafter, in page 63, it was informed to the authorities that on these plots, there are certain shops which have been now extended and encroached over the highway, which is the government land. Your Lordship, the latest report, Your Lordship, kindly excuse me, I have just one copy. I shall read out and hand it over to Your Lordship. The report says, further regarding report against plot number 4 such and such, what is the status of the original petitioner? Here the status is Sri Kalachand Pahar in respect of the encroached land in question. It is to be mentioned that in plot number 538, having recorded classification Pukur and total area 20 decibel of Moja such and such, GL number 250, and in plot number 632, having recorded classification Khana Athoba Khai, total area 51 decibel in Moja such and such, GL number 176, which is adjacent to the PWD plot being number 537, 6857, petitioner, that is Kalachand Pahar, son of such and such, 1 decibel respectively. Presently, both the plots are entirely used as pukur and there is no construction such. Again, it is to be mentioned that another petition such and such. So here it is evident, Your Lordship, that 537, 1657 is the government plot which has been indicated in the order impugned herein. Your Lordship, I shall read out the order. It says, they could not point out any defects or discrepancy in respect of field inquiry conducted by BLLRO EGRA 2. According to the field inquiry report submitted by such and such, encroachment exists on 4 government plots out of 3, bearing plot number such and such. These indications are the plot numbers owned by the government, Your Lordship, where it had the encroachment has taken place, and the property, the plot numbers which are being indicated by the petitioners, that is 838 and 632 are the petitioners' plots which are adjacent to these government plots, Your Lordship. Okay.
The first authority SDO clearly said that
Your Lordship, I shall come to
632 and 538
Your
are
Lordship,
two plots.
I kindly comes to page 94. The private respondent being the petitioners of the WP such and such present, the learned advocate pointed out. Oh, thank you.
Yeah.
The learned advocate pointed out in the title to dispose of pending such and such to plot number 358. Your Lordship, the dispute between the parties is pertaining to 358 and 632, which is pending before the civil suit, and the government is nowhere concerned with those property, Your Lordship. The only concern herein under this proceeding is there any encroachment in over the government land, which has been indicated in page 178.
SDO said ultimately in his order, said that thereby both the roads running through the northern part of plot 538
Yes,
and
Your Lordship.
632 and eastern part of 538 are within the purview of the 64 Act. Therefore, eviction
Yes, Your
was
Lordship.
granted in respect of those plots.
Yes, that land which was not indicated explicitly in the order has been given in details in this order, Your Lordship. The plot numbers of those government land running through these plot is this, Your Lordship. Your Lordship will kindly see, encroachment exists on 4 government plots bearing plot number such and such.
Please see the sentence continues. And the other plot bearing number 537. So these are
And the
separate
other
plots.
plot bearing flap.
So 537 is
Yes,
something
your lordship.
else.
Two, there
There
are
is no
two
mention
plots.
of 632 or 538 here anywhere.
Your lordship, 638, these plots are,
How can we, assume that from this order?
your lordship, this is pertaining to the report which has been suppressed in this writ petition. I shall hand over the report.
Even if
your
it
lordship.
pertains to some report, the report cannot be dehors the original case. The
No, your
appeal is
lordship,
in
the
connection.
report clearly
The
says.
appeal is in connection with only two plots, 632 and 538.
Absolutely, your lordship.
So there is no affirmation on that at all in
Your
the
lordship,
appellate
the
question.
report clearly
Report, I won't look into the report. What does the report has to do with it? The
The
appeal court has to look into it.
Yes,
The
your lordship.
appellate authority has to either affirm or set aside the orders pertaining to plot number 632, 538. There is not a mention in 530 in the appellate authority's order.
Your lordship, 538 and 632, these plots which have been mentioned here are the government lands which are adjacent to those two plots.
This is your explanation, ma'am.
No,
Where is
this
that
has been-
reflected in the order?
Your lordship, this has been
Show me this from the order.
Your
Whatever you're saying.
Your lordship, this has been explained and given in details in the report to which the
I don't
petitioner
bother
has
about the
not
report. Has to be in
raised
the
any
order.
objection.
Whatever may be in the report, it has to be in the order. It has to be reflected in the order. The complaint and the first authority order is regarding two particular plots. Those are not even mentioned in this order.
Your
Appellate
lordship,
authority
those
order.
plots are not government plots, your lordship. Your lordship will kindly read.
If those plots are not government plots, then appellate authority entirely exceeded its jurisdiction in
Your lordship will
saying some other plots are encroached.
Your lordship,
Cannot be done by the
your-
appellate authority for the first
Your
time.
lordship, I shall read the SDO's orders once more for
No, need not.
nice
Need not.
advice.
Need not. Don't
Your lordship,
waste time.
kindly give me one chance to read this order, your
No,
lordship.
don't read the
Once.
entire order.
Your
Read
lordship
the
will
relevant
kindly
portion.
see.
Yes.
Your lordship will kindly see.
Read the relevant portion. Those
I'll read
plots
the
which have been
relevant
mentioned by the appellate authority do not even find mention in this
I
SDO's order.
shall read your lordship. The private respondent being the learned advocate points out that a riayati land, but instead of instant case under Article 10(3) is related to government land used as road, which is beyond 138, 632, and thus being non-contract such and such. Highway, including all government roads within the definition, very highway, and thereby both the roads running through the northern part of 358 and 632. Your lordship, 532. Northern part of your lordship, that is the adjacent, running through the adjacent part, that adjacent road plot number has been mentioned in the final order, your lordship.
Very good.
This is the final.
Yeah, Dr. Sahara now. Yes. What do you say?
My learned friend just now pointed out that there is a discrepancy in the plot. But so far the 632 is concerned, but this is the plot belongs to the private respondent. My lordship, kindly see the order itself. If you're the order which has been handed over to my learned sister, that is the fresh order passed by the on the basis of the report given by the BLRO, where it has been specified the submission of fresh inquiry report involving government plots in front of Rayati plot. Lordship, kindly take the note of that. This is the very important part. In front of the Rayati plot being number 632 of Moja such and such. So this plot where the titles.
What are you reading, Mr. Dr. Sahara?
That is the report. DHN report.
Report report
Yes, Dr. Sahara, the report is immaterial. Show me from the appellate authority's order that it even dealt with 632 or 538.
But 632 has nothing to do because the 632 is the plot belongs to the private respondent.
632 and 538 are the only two plots which are dealt with by the SDO. And the complaint relates to those plots only.
I tell you, Lordship, what happened. But this is the plot which were adjacent to the shops which are run in the government plot run by the petitioners.
This is your explanation, Dr. Sahara.
Lordship, kindly
does not find place in the order.
Kindly see the
Appellate
order.
authority.
Kindly see the order for a moment. But this is the, my lordship, kindly come. Yes, kindly come to page 178. But this is, my lordship, kindly see adjacent to the Rayati land. It has been specified in the report.
Dr. Sahara, I thought it was very simple. I don't know why you are complicating.
No, I am not complicating.
The encroachment, the complaint is regarding plot numbers X and Y, right? SDO decides on plot numbers X and Y and says those are encroached, has to be removed. Now, appellate authority speaks about A and B, and now you are saying A and B are adjacent to that. in front of that, behind that, right side of that.
I tell you,
How is it
Lordship,
relevant
I
even?
tell you, Lordship. Lordship, kindly bear me for a moment, Lordship. Initially, the writ petition has been taken out by the private respondent. This respondent, that is a private respondent before your Lordship. And there was a specific direction passed by Justice Boshap. If your Lordship kindly see the first order, where there is a direction that under the Highway Act, it should be dealt with under subsection 3 of section 10. On that pretext, your Lordship, this matter has been dealt with by the concerned officer under subsection 3 of section 10 of the Highway Authority. And which is the two plot? My grievance was that the government plot, that is within the government plot, and in the part of that plot has been explained, that has been, they are exceeding that jurisdiction and they are using that plot of my land. And they say that since the title suit is pending, so nothing can be decided. Now, on that pretext, the Justice Boshak was pleased to direct to consider this, and they preferred an appeal against that order. That is also there in the appellate authority, appeal court direct that the Highway Authority should decide the matter. They should not touch the plot relating to the two plot where the title suit is pending. That is the plot number 632. But there is a checkered history on that. Now, there again, on that basis that the hearing took place. After this hearing took place, they never raised any objection. No point has been raised regarding this point. Lordship, kindly take, if you Lordship kindly see the first order past page 74. Page 74. Initially, there are several things which has to be dealt with. Now, operative part is page 74, Lordship. Here the petitioner is Kalachat Pradhan, your Lordship will find. That is the private respondent. Whose main grievance is that they are exceeding to my plot, and on that basis, there is a direction since some of the encroachment is in my plot, and on that basis, the direction has been given that under subsection 3, section 10 of the Highway Act, that the matter is to be dealt with. And against that, they preferred an appeal. Lordship then kindly turn to page 75 onwards. The operative part is page 84, starting from page 84, the order. Lordship got that?
Yes.
Your Lordship find that they preferred an appeal, that is a petitioner before your Lordship. In the aforesaid page 85, or in the aforesaid page 85, Lordship, that is all the need done is the competent authority under the State Highway Act will proceed with due action after giving appellate where the private respondent in the writ petition adequate opportunity in accordance with rule to raise such and such. From the aforesaid, we clarify that anything stated in the order passing the writ petition and the input in this writ appeal or stated in this judgment will not stand in the way of the parties to the litigation raising all issues would be German for consideration by competent authority under the State Highway Act. No observation made hereby of the learned single judge to impair the due course of adjudication of any civil suit. So the civil suit, Lordship, is pending relating to this plot. But this is the German issue, Lordship. So far, this plot is concerned, nothing is to be done. Adjoining to that plot. So my learned friends, this is the dilatory tactics on their part, Lordship, to delay justice. What happened that there is a comprehensive report which has been given on the yardstick, which has been specified by the Honorable High Court. There are three yardstick has been specified. What are those? What is the status of the petitioner? How much encroachment they have made to the government land? And if so, what has been done? That there is an entire report on the 3 yardstick which has been already been dealt with by the BLRO report. And there was a discrepancy. On that basis, the discrepancy, a fresh report has to be granted, which my learned friend just now stated, which they failed to disclose before this writ petition, Lordship. And on that basis, this writ petition, it has been specified that there is an encroachment. So far, my plot is concerned and their plot is concerned, that is to be adjudicated before the civil court. So far, 632 and this plot is concerned. So initially, what happened? Lordship, kindly take note that initially, first writ petition has been taken out by me on respect of this plot. On that pretext, this order has been preferred. And thereafter, several litigation has been taken place. My learned friend has taken several litigation in order to delay justice. It has been taken up before your Lordship, and your Lordship was pleased to relegate this matter before the appellate authority. Subsequently, they are not pleased with that order. Again, they have come up with this writ petition. Then the Justice Ghosh was pleased to relegate again this matter to give a fresh hearing on that there is certain yardstick has been provided, And on that basis, fresh BLR report has been considered. And after that, if your lordship kindly see the order itself.
537 is the main.
Lordship, yes. Lordship, kindly consider page 178. But they could not.
Dr. Sara, let me pinpoint my question.
Lordship.
Please come to page 62. Page 62 and 178, I'll be referring to these two pages for the timing. 62 is the complaint, your complaint. Your learned friend for the state is very right in pointing out that 632 and 538 are the civil suit plots. We are not bothered with that. Your complaint, the caption of your complaint says that the encroachment is regarding plots adjacent to 632 and 538, which are 3 plots have been named. 537, 685,
and 862.
And 862. Now, please come back to page 178. Now, 178, insofar as that is concerned, yes, 537 is one of the plots at page 179, 537. Regarding that also, encroachment has been directed to be removed. One. But what about the other two? 685 and 862. Now, please come to the last paragraph of page 178. Now, that does not,
Consider the above facts and of the inquiry.
yes, that does not mention about 685 or 862, but takes into consideration some other plots. Some
682 is 862 is mentioned. 862. Your lordship will kindly see.
43 by 862.
43 by 6.
43 by 862.
So it's a Bata plot, then it's different from 862.
862.
862 and 43 by 862 are different plots. One is a Bata plot, one may be the parent plot. 43 by 862 is not 862.
No, your lordship.
Because what happens after the demarcation, 862 mother plot has been retained. 43 by 862 is one part of it.
Your lordship, the demarcation.
But there was a complaint on that basis. And
complaint was not relating to 43 by 862.
No, I am not talking about the 862. Lordship got the 3 plots.
Yes.
But the 862, then
537.
537.
So where does 43 by 861 and 43 by 862 come in?
I am coming to that. Lordship will find that this is my complaint. And on that basis, the BLRO has made a field inspection. And in the field inspection, BLRO found that this part is encroached. So that it is for the government land, it belongs to the government land.
What the encroachers, where has it been mentioned?
But it has
there may be
mentioned.
other persons than Mr. Pal's client.
Yes, it has been mentioned. In the report, it has been specified. Detailed report has been specified.
Is it restricted to Mr. Pal's clients?
Yes.
Or some others also?
No, Mr. Pal's client.
Please take up and say. Take responsibility for that. Is it you are vociferously relying on the report.
But I am.
So take responsibility.
These portions are restricted only to the petition.
Show me that.
These are
and give a copy to give a copy.
I shall give a copy.
Shall be or given.
Your Lordship, right now I have this copy, but they have already been served with the copy. They already have a copy of the report, which is given to them by the report.
Here.
Your Lordship, the report and the special clarification. Clarification. Your Lordship, the map is also, sketch map has also been annexed.
Right.
It's a dilatory tactics to be.
Very good. Let me come back to Mr. Pal. Yes, take a seat. Mr. Pal, two things.
Lordship.
One is that subsequent reports are there that your client has suppressed in the writ petition.
Lordship.
One. Secondly, 537 is one of the plots which was part of the complaint.
Lordship.
Regarding the other plot 862, the other Bata plots have been mentioned. But if it's restricted to your clients, the report may very well say that you are encroaching on some other plots also.
So what is in the order, Lordship?
That has been reflected in the appellate court's order.
Lordship, that is not that, Lordship. First thing, Lordship.
Yes.
First order was 538 and 632.
First order was bad.
No, Lordship. Why bad?
SDO.
I therefore
SDO order.
Lordship. I therefore don't find any cogent reason to interfere with the order dated 6/11/2019. Passed by SDO, and therefore upheld. Why bad? Has upheld that order. And this order deals with 538 and 632. And Lordship, the order is very clear, including government within the definition of very highway and thereby both the roads running through through the northern part. They are saying this is the in front of, besides that, through the northern part of plot number 533 and 632.
I'll keep your reports on record, but I'll direct the matter. I'll remand the matter back.
Your Lordship,
Has to be taken note of.
Your Lordship, kindly comes to page 94, the order ones.
Yes.
Your Lordship,
Yes.
I
this
shall
one.
indicate only one line, Your Lordship.
Yes. Yes.
The second paragraph, it is recorded that the private respondents, being the petitioners of WP such and such, present through the advocate, learned advocate, pointed out that the title suit was disposed of and pending relating to plot number 358, a Riayati land, but the 538, sorry. Riayati land, but the Riayati land,
Yes.
but the incident such and such, is related to the plot land used as a road, which is beyond the plot 538. It has been mentioned, Your Lordship, which is beyond the 538. And the report and the complaint clearly says the adjacent land to 538 is 537, Your Lordship, which is the government land, Your Lordship.
This is the submission of the private respondent, and the observation is that thereafter, this is a submission of private respondent.
Yes. The petitioner challenges an order passed by the appellate authority directing removal of alleged illegal encroachment by the petitioners. So, next para, it is pointed out that upon an initial complaint by the private respondents, the matter saw several rounds of litigation, by an order dated March 28, 2022, passed in WPA 49, take your seats, 4959 of 2022, it was observed inter alia that the order of the first authority, that is the SDO, which was impugned before the appellate authority,
May I take leave, Lord?
Yes. Sorry, the order of the first appellate authority. First authority থেকে কেটে দিন। First authority কথাটা থেকে কেটে দিন। The order of the appellate authority passed at that point of time that the specific details of the encroached land had not been mentioned, the status of the petitioners in respect of the land in question also was not ascertained, nor was it found specifically as to whether the land was a government land or not. On such premise, the matter was ultimately relegated back to the appellate authority. Upon a further order being passed, a fresh writ petition was preferred, which also met with an order remanding the matter back to the appellate authority on the count that the previous order of this court had not been adhered to. Thereafter, the appellate authority passed the present impugned order, whereby certain particular plots have been held to be government plots and removal of encroachment from the said plots have been directed. Next para, learned counsel for the petitioner argues that the plots which have been alleged to be encroached in the appellate authority's order did not find place in the order of the SDO. Whereas the SDO specifically observed that there was encroachment with regard to roads running through northern part of plot number 538 and 632 and eastern part of plot number 538, which were within the purview of the Highway Act, 1964, and directed the removal of encroachment in that regard, the appellate authority did not mention any of the said two plots, but passed its order directing the removal of alleged encroachment regarding plots 43 by 861, 43 by 862, 1066 by 6857, and plot number 537. Next para, despite having so deviated in its entirety from the plots, the appellate authority found that there was no cogent reason to interfere with the order of the SDO and affirmed the same. Next para, it is submitted that such palpable deviation between the two authorities' orders itself tantamounts to patent perversity. For sub next para, it is further argued that although the initial inquiry report filed before the appellate authority was questioned by the concerned additional district magistrate who directed a fresh inquiry to be held, comma, no such inquiry report is reflected in the impugned order, comma, nor was any copy given to the petitioners. For sub next para, learned counsel argues that since the last order passed by the appellate authority, comma, which has been impugned herein, also does not adhere to the specific observations of this court passed previously, comma, the same is also bad on such count. For sub next para, learned counsel for the state contends that the initial complaint was lodged not with regard to plot numbers 538 and 632, but with regard to plot numbers 537, 685 and 862. It is argued that the submission of the petitioner that no further inquiry was held is misconceived. It is contended that there has been a suppression of material facts inasmuch as a further inquiry was held, comma, the notice of which has also been enclosed with the present writ petition. Upon such fresh inquiry having been held, comma, a copy of the same was also served on the petitioners. On the basis of the said fresh inquiry report, comma, the appellate authority came to its detailed observations which cannot be faulted. Next para, learned counsel appearing for the private respondents adds to the arguments of the state that the appellate authority acted well within its jurisdiction in ascertaining from the inquiry report as to what were the exact plots which had been encroached by the petitioners and passed the impugned order with regard to the same. Next para, insofar as the mention of the plots are concerned, comma, it is argued that the revised report, comma, as clarified subsequently, comma, clearly takes into account all the yardsticks enumerated on the previous occasion by this court. Next para, not only was the exact extent of the encroached land mentioned therein, comma, the status of the petitioners were also duly disclosed. Next para, upon a perusal of the materials annexed to the writ petition, comma, it is palpable that the first authority, that is the SDO, never mentioned the plots which have been enumerated to be encroached by the first appellate authority. The clear finding of the SDO was that there were roads running through the northern part of plot number 538 and 632 and the eastern part of plot number 538, which were, according to the SDO, within the purview of the West Bengal Highways Act 1964. Next para, the SDO went on to observe that the two different government roads were maintained by two different agencies of the government, mainly PWD and PWD within bracket roads. Next para, in continuance thereof, comma, it was directed by the SDO that the representative of PWD remained present and commented that they had nothing to add, and considering the same, the SDO directed the assistant engineer PWD Kontai to take appropriate steps to remove the encroachers where the encroachment had been made over the government land along the road as mentioned therein. Next para, while sitting in judgment over the said order of the SDO dated November 6, 2019, comma, the appellate authority by the impugned order, comma, on the findings had made by him, comma, ultimately observed that there was no cogent reason to interfere with the order dated November 6, 2019 passed by the SDO and upheld the said order. Full stop. Next para. Such affirmation of the palpably perverse order of the SDO was itself vitiated mm, in law. Full stop. In the event, the appellate authority was of the opinion that there was encroachment with regard to certain other plots than those which have been specifically mentioned by the SDO, that is plot numbers 538 and 632, comma, it was the incumbent duty of the appellate authority to remand the matter back to the SDO so that all parties would have a further opportunity of dealing with the said allegations. Full stop. Next para. Otherwise, comma, the effect would be that the appellate authority would be the first authority for all practical purpose, comma, depriving the parties of one appellate forum. Full stop. Since the report furnished before the before the appellate authority apparently depicted a picture which was completely different from the order of the SDO, comma, the said opened a new vista of adjudication, comma, which necessitated the matter to be relegated to the first authority for a comprehensive hearing of the same. Full stop. In the same breath, comma, the appellate authority, comma, while observing that the encroachments were with regard to certain completely different plots from those mentioned by the first authority, comma, would not have affirmed the order of the first authority on such different plots. Full stop. Next para. Of course, comma, insofar as the subsequent report being furnished is concerned, comma, the respondents are justified in saying that the petitioner ought to have disclosed such furnishing of subsequent report and service of copy thereof on the petitioner. Full stop. Next para. Be that as it may, comma, there is no occasion for this court to go into the merits of the contents of the said report. Full stop. Next para. Even otherwise, comma, the respondents are justified in arguing that the authorities had the jurisdiction to observe that there was encroachment with regard to different properties than which were mentioned by the SDO if the reports so suggest. Full stop. However, comma, in view of the above observations, comma, the appropriate forum for deciding such issue, comma, since entirely new plots have come up in the order of the appellate authority, comma, was the first authority, that is the SDO. Full stop. The proper course of action of the appellate authority, comma, if it was of the opinion that the encroachment was of entirely different plots than mentioned by the SDO, comma, was only to remand the matter back to the SDO for a further consideration and not to affirm the palpably faulty order of the SDO, which, comma, even as per the order of the first appellate authority, did not stand the scrutiny of law. Full stop. Next para. Thus, comma, the conclusion of the first authority was contradictory to its observations in that regard. Full stop. Next para. Accordingly, WPA 27391 of 2023 is disposed of by remanding the matter back to the first appellate authority from the stage after the filing of the fresh report by the authority, by the BLLRO. The report was filed by the BLNLRO. Full stop. Next para. The first authority shall proceed from that stage and upon giving না এটা হবে না সেম is disposed of থেকে তারপর বাকি রেখে দিন accordingly WPA 27391 of 2023 is disposed of by remanding the matter back to the concerned SDO. Full stop. The said SDO, comma, upon giving a fresh opportunity of hearing to both parties to produce necessary documents and giving adequate opportunity of hearing to both parties, comma, shall pass a reasoned order on the complaint lodged by the private respondents alleging encroachment. Full stop. Next para. it is made clear that it will be open to the respondents to produce before the first authority, that is the SDO, the inquiry report which was furnished before the first appellate authority, upon the said report having been proved to have been duly authored by the concerned authority, the SDO shall take the same into consideration while making the adjudication as directed above, if necessary, upon giving opportunity to the petitioners to furnish a written objection or address the contents of the said report duly in accordance with law. It is expected that the SDO shall dispose of the proceeding after remand as expeditiously as possible, positively within February 29, 2024. Next para. Bas, this much. No address to cost urgency. It goes back to the SDO. You will be able to furnish that report. You will only have to prove it through the author. And he will have an opportunity to address that.
Grateful, Your Lordship.
Grateful. You are only protracting the matter. Ultimately, you have to go.
Each and every time we have contested regarding this.
They are
But it has
unfortunate.
not been
They're unfortunate because the orders of the authorities are not,
Not
properly addressed.
properly drafted.
properly done.
Only that.
Properly drafted.
So,
Yes.
Upgraded matter item 6.
My Lord, beg to appear for the state respondent, Lordship.
Yes.
My Lord, yesterday, my Lordship was kind enough, my Lord,
Yes.
to allow me to, my Lord, submit and, my Lord,
Yes, Mr. Kali.
on the issue, my Lord, of the
That tender. Right.
extent of, my Lord, judicial review with regard to scrutiny of various, my Lord, clauses of the tender documents, my Lord, and Lordship was pleased to allow me to cite, my Lord, two judgments also, my Lord. I have cited, my Lord, two judgments, that is 2022, two on his NG projects, and another, my Lord, 2023 SEC online, Lordship.
Right.
And I intended to, my Lord, submit two more judgments, cite two more judgments, that is on the question locus, as because, my
You
Lord,
cited three judgments: 2022 6 SCC 127, 2023 SCC online SC 1051, and 2022 SCC online SC 1334.
this I was about to, my Lord, this I was about to, my Lord, this read out this airport authority 2022 SEC online 1334, my Lord. This is, my Lord, the proposition is, my Lord, is with regard to locus vis-a-vis, my Lord, assailing, my Lord, the various clauses of the tender. As because, my Lord, here the petitioner, my Lord, did not participate in the tender, my Lord. So on this, my Lord, ratio, my Lord, may I just, my Lord, read out this particular, my Lord, place this judgment, Lordship. My Lord, kindly see what this is the judgment, my Lord, where, my Lord, the petitioner, my Lord, the appellant being an NGO, it challenged, my Lord, the different clauses of the tender document. And Honorable Supreme Court was pleased to hold that since you were not a participant in the tender, my Lord, that's why you don't have any right to challenge. So on that premise, my Lord, I would like to, my Lord, cite this judgment, Lordship. Paragraph 3, my Lord, is a fact. And, my Lord, paragraph 7, my Lord, kindly comes to, my Lord. May I invite your Lordship to para 7, my Lord. Sri Nataraj, learned Additional Solicitor General appearing for Airport Authority of India has assailed the important impugned judgment and order passed by the High Court inter alia on the following grounds. The original writ petitioner before the High Court has no locus standi to maintain the writ petition. And two, that the terms and condition invitation to tender being in the realm of contract are not open to judicial scrutiny, my Lord. On these two, my Lord, issues, my Lord, kindly see the answer, my Lord. Please, the learned, my Lord, Honorable Supreme Court is giving, my Lord. That starts, my Lord, at paragraph, my Lord, 26 onwards, Lordship.
Yes.
May I read out, Lordship, at the outset, para 26. It is required to be noted that respondent 1, claiming to be a non-profit organization carrying out research, advisory, and advocacy in the field of civil aviation, has filed a petition challenging the tender conditions in the respective RPFs. It is required to be noted that none of the GHA, that is ground handling agencies, who participated in the tender process and or could have participated at the tender process have challenged the tender condition. It is required to be noted
the writ petition before the High Court was not in the nature of public interest litigation. In that view of the matter, it is not appreciable how respondent number 1, original writ petitioner being an NGO, would have any locus standi to maintain the writ petition, challenging the tender conditions in the respective RFPs. Respondent 1 cannot be said to be an aggrieved party. Therefore, in the present case, the High Court has erred in entertaining the writ petition at the instance of respondent number 1, challenging the eligibility criteria, tender conditions mentioned in the respective RFPs. The High Court ought to have dismissed the writ petition on the ground of locus standi of respondent number 1, original writ petitioner, to maintain writ petition. 27, my lord, kindly comes to my lord. Even otherwise, even on merits also, the High Court has erred in quashing and setting aside the eligibility criteria, tender conditions mentioned in the respective RFPs, while exercising the power under Article 226 of the Constitution of India. As per the settled position of law, the terms and conditions of the invitation to tender are within the domain of the tenderer, tender-making authority, and are not open to judicial scrutiny unless they are arbitrary, discriminatory, or malafide. As per the settled proposition of law, the terms of the invitation to tender are not open to judicial scrutiny, the same being the realm of contract. The government, tenderer, tender-making authority must have a free hand in setting the terms of the tender. Para 28, my lord. While considering the scope and ambit of the High Court under Article 226 of the Constitution of India with regard to judicial scrutiny of the eligibility criteria, tender conditions, few decisions of this court are required to be referred to, my lord. So, my lord, it has referred to, my lord, a number of judgments, my lord, starting from paragraph 29 onwards. So 29, I'd like to, my lord, rely upon, and paragraph 30, my lord, clause C, kindly cease. Clause C says, in the matter of formulating conditions of a tender document and awarding a contract, greater latitude is required to be conceded to the state authorities unless the action of the tendering authority is found to be malicious and a misuse of its statutory powers. Interference by courts is not warranted. And, my lord, kindly, my lord, comes to, my lord, 31, my lord. In the aforesaid decision, it is further observed the government and their undertakings must have a free hand in setting terms of the tender, and only if it is arbitrary, discriminatory, malafide, or actuated by bias, this court would interfere. It is further observed that courts cannot interfere with the terms of the tender prescribed by the government because it feels that some of the terms in the tender would have been fair, wiser, or logical. Similar views have been expressed in the case of so-and-so. My lord, may I just read out 34 and 35? Last. Having gone through the respective clauses, conditions which are held to be arbitrary and illegal by the High Court, we are of the opinion that the same cannot be said to be arbitrary and or malafide and or actuated by bias. It was for the AI to decide its own terms and fix the eligibility criteria. Applying the law laid down by this court in the aforesaid decisions, we are of the opinion the High Court has committed a serious error in, first of all, entertaining the writ petition at the instance of respondent number 1, original writ petitioner, an NGO, and also holding the relevant eligibility criteria conditions mentioned in the tender documents is illegal. Because in tandem with this particular judgment, ratio settled, my lord, in this judgment, may I just, my lord, respectfully, my lord, request your lordship, my lord, to come to some of the averments, 2 or 3 paragraphs and 1 page of this, my lord, writ petition kindly comes, my lord. Why I am, my lord, referring to this? My lord, kindly, my lord, may I respectfully, my lord, invite your lordship, my lord, to, my lord, page 48, my lord, of the writ petition, lordship. This is, my lord, may I respectfully invite, my lord, your lordship to clause 6, my lord. Page 48, clause 6.
Yes, 6.
My lord, clause 6, my lord, refers to, my lord, eligible and qualified bidders. So this is an eligibility clause. My lord, the bidder should have applied in any 3 years after 2011 from the date of tender opening at least 100% of the quoted quantity of similar goods or service meeting major specifications, parameters, which law is functioning. This is one of the specific grounds, the eligibility, the basic criterion, which has been assailed, my lord, by the, my lord, the petitioner, despite not having participated in the tender. Kindly see paragraph. My lord, kindly comes to, my lord, page 5, my lord. of the Milord rate petition. And kindly seize, Milord, clause B. Eligibility.
Yes.
This also finds, Milord, place in the representation, Milord, preferred by the petitioner at page 85 also. Representations were pointed on two grounds. One is why one supervisor for 214, and second, Milord, point is eligibility. Why you are asking for 100% that you had an experience of dealing with this 100%. That means we are floating the tenure of 214 plus 1. So you had the experience of dealing with this type of 214 plus 1 personnel type. Why are you asking for this? So when he is assailing the very eligibility, Milord. Milord, second, Milord, next judgment, Milord. So, Milord, may I respectfully submit that locus standi, Milord, to challenge, Milord, the tender document is coterminous, Milord, with participation in the tender, Milord. Being on the fence, and Milord, trying to challenge it, Milord, because, Milord, I had the occasion to go through several judgments, Milord, on the tender, Milord, matter, Milord. Milord, respectfully submit, subject to the correction of this honorable court and my learned friend also, Milord. Never did I see, Milord, the sitting on the fence did not participate, but challenging, Milord, the tender documents. Milord, my learned friend has prayed for mandamus and also for declaration. Even declaration, Milord, that is clause A prayer, is, Milord, akin to, Milord, section 34 of the SR Act, which also speaks of a semblance of right. Milord, mandamus, Milord, may I just cite, Milord, one judgment on this? May I just cite one judgment, Lordship? Milord, 1976, Milord, 1 SCC, Milord, 671. It's a, Milord, 4-judge bench judgment of the Honorable Supreme Court, Lordship. (176) 1976, 1 SCC 671. Milord, here, Milord, the background of the case was that for a cinema theatre, NOC was given to one particular person.
Yes, Mr. Bogali, please continue.
Background of this case was, Milord, the cinema theatre NOC was given by the state government to one Mr. X. Suddenly somebody else comes. He happens to have one cinema theatre and telling, no, there is a burial ground in the vicinity of that particular cinema theatre to whom you have given the NOC. Yes. So I have objection to that. Dealing on this, Milord, Honorable Supreme Court had the occasion, Milord, to say something, Milord. Kindly seize, Milord. Paragraphs, Milord. 34. Milord, kindly, Milord, may I respectfully, Milord, invite your Lordship, Milord, to paragraph, Milord, 34, Milord. This court has laid down a number of decisions that, in order to have a locus standi to invoke the extraordinary jurisdiction under Article 226, an applicant should ordinarily be one who has a personal or individual interest in the subject matter application. Though in the case of some of writs like habeas corpus or quo warranto, this rule is relaxed or modified. In other words, as a general rule, infringement of some legal right or prejudice to some legal interest inhering in the petition is necessary to give a locus standi in the matter. So, Milord, only relaxation regard to locus is writ of habeas corpus and writ of quo warranto. Milord, may I just, Milord, read out paragraph 36 and 36, 48 and 49. Kindly see 36, Milord. In the United States of America, also the law on the point is substantially the same. And quoting, Milord, one case, Milord, Coleman. Thereafter, kindly sees the observation. To have a standing to sue. Lordship got that? Which means locus standi to ask for relief in a court independently of a statutory remedy. The plaintiff must show that he is injured, that is subjected to or threatened with a legal wrong. Courts can intervene only where legal rights are invaded. Legal wrong requires a judicially enforceable right, and the touchstone to judiciability is injury to a legally protected right. A nominal or a highly speculative adverse effect on the interest or right of a person has been held to be insufficient to give him the standing to sue for judicial review of administrative action. Again, the adverse effect requisite for standing to sue must be an illegal effect. Thus, in the undermentioned case, it was held that injury resulting from lawful competition, not being a legal wrong, cannot furnish a standing to sue for a judicial review. So it's a speculative. I did not participate. This might happen to me, that might happen to me. So I will not participate. Now, Milord, kindly, Milord, comes to Milord. 48, Lordship, kindly, Milord. In the light of the above discussion, it is demonstrably clear that the appellant has not been denied or deprived of a legal right. He has not sustained injury to any legally protected interest. In fact, the impugned order does not operate as a decision against him, much less does it wrongfully affect his title to something. He has not been subjected to a legal wrong. He has suffered no legal grievance. He has no legal peg for a justiciable claim to hang on. Therefore, he is not a person aggrieved and has no locus standi to challenge the grant of no objection certificate. And the paragraph 49, it is true that in the ultimate analysis, the jurisdiction article 220 in general and certiorari in particular is discretionary. But in a country like India, where writ petitions are instituted in the high courts by the thousands, many of them frivolous, a strict ascertainment at the outset of the standing of the petitioner to invoke this extraordinary jurisdiction must be insisted upon. The broad guidelines indicated by us, coupled with other established self-devised rules of practice such as the availability of an alternative remedy, the conduct of the petitioner, etc., can go a long way to help the courts in weeding out a large number of writ petitions at the initial stage with consequence. Milord, denied and deprived of. Milord, paragraph 48. Milord, may I just, Milord, respectfully, Milord, invite, Milord, your lordship, Milord, kindly seize, Milord, paragraph, Milord, 24 of the writ petition, Milord.
Yes.
In absence of appropriate clarification of the issues arising out of the peculiar, contradictory, and unprecedented clauses contained in the need, the petitioner cannot participate in the interview process, tender process by submitting its online bid, the closing date of which is 29 November, so and so, so and so. So cannot participate. So this is not a case of denial or deprivation. Milord, in tandem with this, Milord, kindly, Milord, may I respectfully invite your lordship, Milord, to paragraph 4 of the averment also. Kindly see the content and intent of this particular paragraph. In paragraph 4, Milord, my learned friend says, the petitioner who has been satisfactorily providing similar services of housekeeping and scavenging cleaning at Malda Medical College and Hospital has sufficient credentials for participating in any tender floated by any hospital run by the state government or central government in providing housekeeping and scavenging cleaning services. Since the process of tender is competitive to the business of the petitioner is inclined to keep such information confidential from the eyes of competitive bidders and therefore craves leave to produce documents certifying its credentials in a sealed envelope only for reference of the Honorable Court as and when necessary. So, Milord, he is willing to keep his cards close to his chest. And Milord, on 20th November, Milord, kindly see the jurat portion. He affirms an affidavit and Milord challenges that all these are wrong, these are wrong, these are wrong. Representation is only on 2 points at page 85. That why 214 personnel and 1 supervisor, and this why this eligibility. So, Milord's content and intent of these 2 paragraphs, para 4 and 24, Milord, can't be said in my respectful submission that it was a denial or deprival of, Milord, the rights, Milord, if he at all alleges, as, Milord, envisaged, Milord, under Article 19(1)(g) of the Constitution. Although it has not been pleaded in the petition. I've checked the petition. It has not been pleaded. Article 19(1)(g). Nonetheless, Milord, Article 19(1)(g), Lordship knows, Milord, we have learned from your Lordship, Milord, it is subject to restriction. Restriction includes any eligibility. That is Article 19(1)(g), subclause 6. And, Milord, qualification eligibility is a part of restriction, Milord, and it also includes notification. Notification comes, Milord, under the definition of law, which is enshrined in Article 13. So, Milord, 19(1)(g) is not pleaded in the petition. Nonetheless, Milord, so he is, Milord, just sitting on the fence, trying to create a locus and challenge the entire, Milord, clauses of the tender, Milord, whereas his main principal grievance before filing of this writ petition, in the representation was two. One on eligibility, other on this 214 plus 1. Why? Now, my lord, yesterday, my lord, I will just refer to some pages, my lord, and I will close my argument. These are the only judgments, my lord, I would like to refer to, lordship. Yesterday, my learned friend, my lord, has referred to, my lord, one clause which I also, my lord, in the perspective of assisting your lordship, could not. Kindly seize, my lord, this word boy, lordship. Lordship at page 45, my lord. I'm sorry, my lord, I'm taking some time, lordship, my lord.
No. Yes.
Page 45, my lord. Lordship was pleased to ask me that that patient support services, the patient support services which shall be required to be rendered by a ward boys shall comprise the following. Lordship was pleased to ask me that if you say ward boy is somebody else or some other section, some other sector, then why in a tender for this cleaning and housekeeping you have brought in the issue of this? Lordship, I was, my lord, a little, my lord, there was a deficiency of service on my part in assisting you this honorable court, my lord. May I, my lord, respectfully, my lord, invite, my lord, your lordship, my lord, to page 31 of the, my lord, NIT. The 10 notice inviting tender, my lord.
Yes, 31.
My lord, may I read out, my lord? Kindly see this, that is part section 3 of the, my lord, tender. Requirement and EMD.
Yes.
Honest money deposit, EMD. And kindly see, my lord, goods and services, and next column, trained cleaning and housing staff in unskilled, semi-skilled, with uniform and I-card for. All these are needed. Words, OPD, emergency, operation theatre, losses, serial, my lord, kindly see. So these is the tender for. The tender is for trained cleaning and housing staff and for all these.
Trained in what? Diagnostic and treatment procedures. Page 46, first bullet point is that.
Assist the nurse, lordship.
In? Not only assist the nurses, assist everybody, every ward boy has to assist the doctor and nurse. No doubt on that.
Lordship.
But you are very specific. Assist the nurses or doctors in diagnostic and treatment procedures. How?
Well, it is handling, lordship. Kindly sees, my lord. Kindly sees.
Handling the patients while the injection is being given, or what?
Kindly sees one point, my lord. Kindly sees at page 31.
31, yes.
This OPD also it is needed. Emergency, operation theatre, labor
everywhere
room.
they are needed, Mr. Galib. Obviously, everywhere they are needed.
Lordship.
They even have to take via stretchers. They have to take the patients to every department.
Lordship.
That is not the point. But why in diagnostic and treatment procedures? This is one of the aspects. The other aspects are also there. How do you explain? Still explain that.
May I respectfully, my lord, in my own minute, means the entire, my lord, is word, my lord, is circumscribed, my lord, with the, my lord, prefix, my lord, assist, my lord, only assistance, my lord.
Get it.
And that is, my lord, to the nurses, my lord.
Or doctors.
Or doctors, my lord.
Yes.
Well, I may be wrong, lordship, my lord,
No, very
respectfully,
good.
my lord, lordship. And my lord, page 35 also, my lord, kindly see the areas of works also is referred to, my lord. Page 35, area of work. These are the areas of works also, lordship, mentioned, lordship. Page 35, lordship. And my lord, page 36 also, my lord, kindly see clause D.
Achha, where was that clause that we pointed out that the each shift?
That one, lordship, at page 46, my lord.
46.
At the bottom. Supervisor in each shift.
You're right. Yes.
Lordship. So, my lord, kindly sees the nature of work, my lord, page
35 also.
Lordship. 36, clause D, my lord, kindly say, apart from cleaning and housekeeping services, as described below, the housekeeping staff shall also assist the hospital nursing staff in day-to-day patient care, such as receiving and dropping at the entrance. So, my lord, the catchword is, my lord, assistance, my lord.
Right.
That is a catchword in my respectful submission, lordship, before your lordship. And, my lord, My learned friend, my lord, has referred to, my lord, one paragraph that why government, my lord, it has referred to one outdated finance those and not that, my lord. In case of tie, both L1,
right,
it is to be done by toss.
yes.
It is at page 63, my lord, I believe, my lord.
Yes,
Yes,
63.
lordship. In case of more than one L1 bidder, the provisions mentioned in memo number so and so, dated 29 October 2021, issued with the concurrence of Finance Department, will be attracted. My learned friend is very much correct, my lord, that in supersession of this particular 29th October 2021 memo, there was a subsequent memo, and that is dated 7th June 2022. But, my lord, basic premise, my lord, the very sense and essence of this, in case of more than L1 bidder, the language of, my lord, if you lordship, my lord, respectfully, my lord, you may invite at page 88. Kindly see the language. 88, my lord. Seal clause 1. Lordship.
Complete it.
Seal bid should be invited from L1 bidders, and the bidder quoting the lowest rate in the seal bids be accepted. However, the seal bid cannot be more than L1 bid already discovered. And kindly see the language, the same clause at page 91 in the subsequent, my lord, notification. My lord, second, keeping the discovered LI rate as ceiling, very much equal, seal bill may be invited from all the L1 bidders, and out of those, the lowest one may be selected. So discovered L1 will be regarded as ceiling. That is the word used. But in the earlier one, that however, sealed bid cannot be more than L1 already discovered. So yes, ceiling here is a long sentence in the earlier one. And next, my lord, my learned friend, my lord, last. Roshi, I have already handed over yesterday, I had handed over, my lord, that attendance sheet of the pre-bid meeting, where, my lord, neither the petitioner himself nor any representative was found to be present. It is a signed bid.
Yes.
And, my lord, in, my lord, kindly see in the tender document, there is a clause to that effect.
Yes, so we'll continue tomorrow. Yes. Today there's a resolution of the bar at 2.
Not.
No, if there are urgent matters, I will sit. If I can sit, then I'll come back at 2. I'll come back at 2.
No.
But other side will not be here. That's the difficulty. My prayer
If there is extreme urgency, I'll take up and pass orders. No difficulty.
My activity the matter simple.
No, I cannot assure positions.
Item number
If you do it today, I can come back. No difficulty on my part.
item number
I cannot
30.
assure positions. There are so many matters. I'll come back at 2 then. If you are there, which is your item? No, I'll come
My
back.
lord, item number 32, there's a grave urgency. Your
I'll come back
lordship.
at 2. Let us
Lordship
see.
deeply obliged, my lord.
So this matter continues tomorrow. Today.
I will.
Very well. তাহলে কোনো order record question, it will continue after 2 then?
Yeah, I will complete this matter.
Very well, we'll continue after 2.
Since your lordship is already in season.
I'll continue after 2.
Lordship, I
Right.
must be respectfully, my lord.
continue.
Continuing matter, item 6.
And Lordship, my lord,
Yes.
I'm in the last leg of my argument, my lord.
Right.
Lordship, my lord, kindly, my lord, refers to my lord. My lord, may I respectfully, my lord, invite your lordship, my lord, to page, my lord, 49, my lord, of the writ petition, lordship.
Yes.
My lord, kindly sees, my lord, a bidder, kindly sees, my lord, clause 9.1. A bidder requiring any clarification or elucidation on any issue of the tender document may take up the same with the health facility unit in the pre-bid meeting. So, I have already handed up the document that he did not attend the pre-bid meeting. And my lord, my learned friend, my lord, has annexed, my lord, this minutes of the meeting, wherefrom also it is crystal clear that they were all together, my lord, comprising the officials as well as the participants. 18 participants were there in the pre-bid meeting. Pre-bid meeting. I had handed over.
Page 87, it has been annexed.
Lordship, 87 is it is the minutes. Kindly sees that the top, my lord, it's a
Yes, minute.
And my lord, the decisions arrived at.
Right.
At the bottom, the principal so and so. These were the issues raised by the
You have also annexed the chart showing the presence. You have also annexed the chart showing the presence.
I am handing over now.
Right.
And my learned friend could annex only page 87.
Yes, same names are there. No difference.
Same names. So signed attendance sheet shows that he was not. So my lord, this was not taken because 2. Second, my lord, kindly see 9.2 at page 49.
Yes.
The bidder may also take up the same in writing. The health facility unit will respond in writing to such requests, provided the same is received by the health facility unit not later than 8 days prior to the prescribed date of submission of bid. This, my lord, which my learned friend claims to have made with the representation at page 85. But this kindly sees the conclusion. Only 2 points I'll show from this particular representation. Date is 7 November. That is not 8 days prior to the submission, because submission of bid started on 13th October 2023. That will appear at page 27. That will appear at page 27. That is a neat bid document. Schedule. October 2023, online bid submission start date. And downloading Miller started from 12th October. So, Miller, language of this 9.2 is the bidder may also take up the lordship. Same in writing. So, after pre-bid meeting, he may also take up it in writing. But in the writ petition, he claims to have attended the pre-bid meeting, raised the issues which are 2 in number in the representations, but multiple challenges in the writ petition, touching different other clauses. Our stand is he did not attend the pre-bid meeting. Signed attendance sheet shows that. And saying this writing, my lord, is, if at all given, it was not, my lord, 8 days prior to, that comes to 6 days. And, my lord, if your lordship, my lord, kindly sees the conclusion, the content, my lord, of the, my lord, representation. Firstly, he starts with in view of the above tender so and so, 214.1 supervisor. For 3 weeks, I beg to state as follows. Thereafter, he points out 2 deficiencies according to him. Absurd clauses. Thereafter, after attending the pre-bid meeting held on 7 November 20, as an interested bona fide bidder, I feel that it is important for the tender committee as well as your good office to consider the tender in view of the above and in accordance with law. What sort of clarification languages he should have for a clarification? Or elucidation. That is the language of the bid document. So this was, my lord, is not there. And finally, at 86, my lord, my learned friend, my lord, prayed for on 14th November. He prays for that in this connection, you are requested to inform us regarding the resolution taken in the said meeting. Our stand is the resolution is uploaded on the portal 24/7 for Tom, Dick, Harry, everybody. And so far, my lordship has been pleased to observe at 87, they kindly sees that those who attended the pre-bid meetings on 7th November 2023, on the basis of the issues raised by them, throwing light on those issues, my lord, the decisions were taken, which will appear from page 87. May I read out the second part? The principal Murshidabad MCH took the chair. Brief discussion was made from the dais. The intending bidder, their representative, raised some issues and the decision was made as follows. So, kindly see from 1 to 10, issues were with regard to rates of 215. Some were referring to EPF, ESI issues. Some were referring to kindly see, but none referred as to the anomalies, absurdities, my lord, legalities, and so on and so forth, my lord. So far as 214 plus 1, it was raised payment of. And
these are different issues. Only the last issue relates to one of their points.
After financial evaluation of the tender, if 2 or more selected as allowed bidder, will be done based on prevailing geo, subject to absurd. So if it is prevailing geo, but the bid document specifies the geo. So if we say take this word with that, the comparative, so
as
prevailing
said,
comes the latest.
As you said, the last.
Latest.
Right.
And essence of the language, so far as this, I shall not repeat, is not different.
Right.
That is, discovered L1 will be regarded as ceiling.
Yes, any reply?
So these are my respective submissions, my lord.
Thank you.
For technical bid, my lord, we found that 24 participants.
24 you said.
Yes, we have handed over, and scrutiny of the tender, this technical, are going on, lordship. These are the 24.
Right.
My lord, I understand that what I could gather from the submissions made by my learned senior colleague is that I do not have any locus because I don't qualify. To that extent, my lord,
You did not participate, he said.
I did not participate. And my lord, I'll also come to that. He said that I did not participate, and referring to the requirement of 100% eligibility, satisfaction of having my lord, supplied similar 100% work. My lord, I am also not eligible. I could not have even participated. Now, my lord, to that, 2 judgments has been referred. My lord, one is 1976. This says that, my lord, unless my legal right is hampered, I cannot come to court. And it has been said that the legal right will hampered only when I have a right to participate. I am eligible for participation. Then only I can say that that right has been infringed, and then only I can come to court. So, my lord, if I understand correctly, if I can show that I do not suffer from any threshold, my lord, bar to participate, as has been pointed out, referring to that 100% eligibility criteria, my lord, I believe, my lord, I will be able to tide over that point. In addition, my lord, I will also refer to the judgment which has been referred, especially, my lord, the airport authority, which says that without participation, So, my lord, the first thing is 100% eligibility criteria. My lord, as has already been pointed out, this was available to me in the pleadings, but I had not taken this before your lordships. There is a reason why. My lord, let me take your lordships back to that page. 48. My lord, page 48, my lord, is right? Yes. Yes, my lord. 6.1. The bidder should have supplied in any 3 years after 2011 from the date of tender opening at least 100% of the quoted quality of the similar goods and or services meeting major specification parameters which has its functioning preferably in a government or corporate MCH hospital establishment and similar size. Now, my lord, this notice inviting tender, my lord, has been issued in the month of October 2023, this year. So, my lord, before October 2023, I have already pleaded that I already carry on similar nature of work in a very similar institution run by the same authorities, my lord, which is the state of West Bengal, my lord, Malda Medical College. Now, my lord, I have these documents with me.
I won't go into that. New documents I won't go into at the reply stage.
My lord, why I had, my lord, said that, my lord, I have already pleaded this and I have craved leave for this honorable courts.
Yes, you have.
Yes,
You
my lord.
placed that also.
Yes. So, my lord, if that is to be looked into, my lord, I say that, my lord, I supply similar, my lord, this pleading is already there. I carry on similar work and coincidentally the numbers are much higher than 215. So, not only 100% I qualify for more than that. And, my lord, just to ease the conscience of the court, I say why this was said that I undertake to place this in a sealed cover. My lord, item number 61 before
You
your...
also gave the reason there, competitive. Because
Yes.
it's competitive.
And it has happened. Item number 61 before your lordship today's list, my lord, is on the same ground I am briefed in the matter. And it has happened. So, my lord, it is beyond any doubt, my lord, and they also have the information that I serve with more than 100% eligibility criteria. So, this threshold bar, my lord, does not apply on me. Point number 1. So, my lord, taking your lordships back to the reports which has been placed before this honorable court to buttress the point that without participation, my lord, I could not have had challenged. My lord, the judgment referred was 2022 SCC Online SC 1334, Airport Authority of India versus Center for Aviation Policy. My lord, paragraph 7 there was relied on. Shri K.M. Nataraj, Learned Additional Solicitor General of India, appearing for AAI, has assailed the impugned judgment and order passed by the Honorable High Court inter alia on the following grounds: that the original writ petition before the High Court has no locus to maintain the writ petition, that the term and condition invitation to tender being in the realm of contract are not open to the judicial scrutiny. These were the two submissions which were relied upon and the findings therefrom. Now, my lord, in this judgment only in the next paragraph, paragraph 8, elaborating the aforesaid grounds, it is vehemently submitted by Shri K.M. Nataraj, the learned ASD, that the original writ petitioner claims to be a non-profit organization carrying out independent research, advisory and advocacy in the field of civil aviation. It is submitted that as per the settled position, NGOs have no locus standi to maintain a writ petition challenging the tender conditions, especially when the same is not in the nature of a public interest litigation. So, my lord, here the petitioner and the premise on which this findings or this argument was even made is the nature of the petitioner is such that it cannot participate in the process which it seeks to challenge. I, my lord, have made out the specific case that not only I am engaged in the same business, but I have this eligibility to participate in the tender process. So, this judgment, my lord, will have no application, I humbly submit, in my case, my lord. My lord, these similar, my lord, findings have been also there in 26, paragraph 26.
Yes.
And, my lord, I would also rely on paragraph 27 from this judgment since we are at it. My lord, even otherwise, even on merits also, the High Court had erred in quashing and setting aside the eligibility criteria tender conditions mentioned in the respective RPFs while exercising the powers under Article 226 of the Constitution of India. As per the settled position of law, the terms and conditions of the invitation to tender are within the domain of tenderer or tender making authority and are not open to judicial scrutiny unless they are arbitrary, discriminatory, or malified. But I have made out this case of arbitrariness my lord, because of being contrary to each other and because of impossibility of performance, my lord, and my lord also discriminatory because it unsettles such clause, unsettles the level playing field for a my lord, prospective bidder. So I, placing on reliance on this, my lord, I say, since this exception carved out by this judgment only applies to my case, the other portions of this judgment will have no manner of application in my case, my lord. This honorable court, my lord, will have the authority to intervene because their arbitrary conditions are present. The same findings are also there in paragraph 31.
Yes.
Yes, my lord. In so far as, my lord, the other judgment which has been placed before this honorable court, my lord, 2023 SCC online SC 1051. My lord, this again will have no manner of application at the outset, at least for the point that this judgment was on a premise where, my lord, an unsuccessful tenderer had come to the court and the court had observed, right away, let me take your lordships. Yes. My lord, at paragraph 35, before we, has my lord got it?
Yes.
Before we part, we would do well to remind ourselves of the words of caution administered by this court in Jagadish Mandal versus State of Odisha. Speaking for the court, Justice R.V. Ravindran said, attempts by unsuccessful tenderers with imaginary grievances, wounded pride, and business rivalry to make mountains out of molehills of some technical procedural violation or prejudice to self and persuade courts to interfere by exercising power of judicial review should be restricted. But first thing is, I have not even participated because I said that it was not by choice that I did not participate. I could not participate because of this restrictive and illegal terms. So the question of my being unsuccessful, my lord, a sole loser coming to court does not arise first. Secondly, my lord, this says that allegations based on imaginary grievances, wounded pride and business rivalry to make mountains out of molehills. My lord, I had, my lord, pointed out before your lordships the clauses which are patently illegal or patently contradictory or, my lord, patently, my lord, impossible to perform. So, my lord, this is not a case where the court will have to go into, my lord, an exercise of reading through many clauses to find out in relation to each other whether it is, my lord, actually possible or impossible. It is on the face of it apparent. So this will again have no manner of application, my lord, in my case. And, my lord, in the same paragraph, my lord, will find there are two enumerations. Paragraph 35, there paragraph 22 of the judgment is quoted. Thereafter, my lord, there is point Roman 1 or then says, whether the process adopted or decision made is so arbitrary and irrational that the court can say that decision is such that no responsible authority acting reasonably and in accordance with relevant law could have reached, or whether public interest is affected. Both this applies in my case. My lord, engaging, my lord, cleaning and housekeeping staff to assist, and I will come to that, assist, that is illegal. Assisting is illegal. And I'll come to this, I'll satisfy the court on this. This will not, my lord, help public interest. My lord, that will be contrary to it. Even, my lord, otherwise this one supervisor, this impossibility to perform is again going to harm public interest at the end of the day, in addition to harming my interest. And, my lord, the next judgment which was cited, which was, my lord, placed before this honorable court is 2022 volume 6 SCC page 127.
Yes.
Thank you. My lord, para 12 was relied upon. Yes.
Yes.
In Afcons Infrastructure Limited versus Nagpur Metro Rail Corporation Limited, this court held that the owner or the employer of a project having authored the tender documents is the best person to understand and appreciate its requirement and interpret its document. It was held as under. In other words, a mere disagreement with the decision-making process or the decision of the administrative authority is no reason for a constitutional court to interfere. This was relied upon. The next sentence itself says, the threshold of malafide is intention to favor someone or arbitrariness, irrationality or perversity must be met before the constitutional court interferes with the decision making process of the decision. These Milord criteria are present in this Milord instant case, Milords, inviting Milord your lordship's interference in this matter. Milord, there are other Milord paragraphs which was also relied upon. However, Milord, I will take your lordships only to paragraph 15. The opening portion was relied upon by the respondents. Milord, thereafter, in 15, there is Milord paragraph 2 within quotation.
Yes.
From that, Milord, portion I must rely upon before your lordship. The judicial review of such contractual matters has its own limitations. In this context of judicial review, administrative actions that this court has opined that it is intended to prevent arbitrariness, irrationality, unreasonableness, bias, and malafide. The purpose is to check whether the choice of decision is made lawfully and not to check whether the choice of decision is sound. So, Milord, I am not inviting your lordships to go into this question that whether a better decision could have been taken. Milord, what I say is that this decision which was taken to include these clauses in the tender, especially that illegal clause, could not have been done altogether. And this is patent on a plain reading of the Milord tender terms. So, Milord, my respectful submission will be, Milord, that these judgments will, Milord, subject to correction by your lordship, will go on to aid my case which I have placed before your lordships in view of the paragraphs which I have read before this honorable court right now. And Milord, Milord, before leaving this judgment, Milord, and going on to my next point, paragraph 26 may also be, Milord, taken note of once. Why this judgment, Milord, was given in a completely different premise.
Yes.
A word of caution ought to be mentioned herein that any contract of public service should not be interfered with lightly, and in any case there should not be any interim order derailing the entire process of the services meant for larger public good. The grant of interim injunction by the learned single bench of the High Court has helped no one except a contractor who lost a contract bid. Again, the case is completely different and has only caused loss to the state with no corresponding gain to anyone. Now, Milord, I say, as I have already said just now, Milord, that this, if allowed, will harm the public. In addition to harming me, Milord.
Yes.
So, Milord, in addition to this, just a minute. এটা না অন্যটা দাও। Milord, this judgment I would rely upon, Milord.
No new judgment in reply.
Milord?
No new judgment in reply. You're in reply.
All right, Milord, I'll then, Milord, just illegality on this point, since it was raised by Milord, my other side, but I'll not place judgments.
What is the contention? Tell me.
Milord, the contention is that the tender terms, if illegal, the court will interfere.
Yes, if illegal, definitely.
Yes, and this is illegal. And Milord, just because, Milord, this assistance portion has been contended while Milord, while giving reply to my contentions that it is just to assist.
Yes.
Milord, may I place before your lordship that, Milord, assisting is also illegal. If your
It's a
lordship,
law.
Yes, the law.
It is the law. A law you can place. Yes.
Yes. Milord, this is West Bengal Allied Medical and Paramedical Council Act 2015. This has been also very recently amended in 2019, but that amendment, Milord, will have no such bearing in this case.
Right.
Though the amendment, Milord, probably is available at the last. Milord, I draw your lordship's attention, Milord, to the definition clause first. Yes. Milord, 2. Wait. Milord, 2C.
Yes.
Allied medical professional means any person having adequate professional qualification who can practice his profession to assist a registered medical practitioner in practice or teaching or research of medicine, and who can also administer appropriate non-pharmacological therapy, and shall include professionals like physiotherapist, occupational therapist, clinical psychologist, nutritionist, etc., or those educated in such disciplines as mentioned in Part A of Schedule 2, but shall not include pharmacists, nurses, or paramedical professionals. Now, my lord, let us come to 2P. My lord, which is again a definition clause, my lord, of paramedical professionals. Paramedical professionals means any person having adequate professional qualification who can practice his profession to assist a registered medical practitioner in practice. Again, my lord, assist a registered medical practitioner in practice or teaching or research of medicine, but who cannot administer any pharmacological or non-pharmacological therapy, and shall include professionals like medical technician or technologists, medical technician or technologists, educated, etc., educated in such disciplines as mentioned in Part B of Schedule 2, but shall not include pharmacists, nurses, or allied medical professionals. So, my lord, allied medical and paramedical professionals, both, my lord, assist medical practitioners. And, my lord, whether or not they can administer any pharmacological or non-pharmacological therapy in the course of such assistance, they will, my lord, either fall under 2C or 2P, either allied medical or paramedical. Now, my lord, I take your lordships to this section 51 of this act, which lays down, I will not take your lordships through it completely, eligibility criteria, my lord, for registration in the register as of paramedical and allied medical. Yes.
Obviously, that's a specialist job also.
Yes.
They have to be qualified specially under this.
Qualified specialist.
Show me the bar.
Yes. 65. Note 65. 1. The practice of allied medical or paramedical profession shall be regulated by the following terms and conditions. No person shall practice the professions mentioned under this act or attempt to act as assume the title or designation of or otherwise purport to be or perform the professional aspect of an allied medical or paramedical professional without possessing a valid certification of registration. Lord, may I take your lordships to E? Yes. The practice by any allied medical or paramedical professional shall always be carried out under the superintendence of a registered medical practitioner unless permitted otherwise by the council. My lord, it also contemplates something else in B. Notwithstanding anything contained in clause A, certain functions that are deemed by the council to be non-professional aspects of allied medical or paramedical science and technology may be performed by an aide or technician as may be acceptable to the council under the superintendence of an allied medical or paramedical professional and subject to such regulations as may be made regarding such assistance or their work. So there is a complete criteria for that. My lord, it will have to be, my lord, performed by an aide or technician as may be acceptable by the council and subject to such regulations as may be made. So, my lord, the first bar applies in this case. No person shall practice the profession. My lord, by this I say that this attempt of including, my lord, this clause whereby it has been said that these cleaning and housekeeping staffs will assist. Even this assistance is forbidden by, my lord, the law which is presently there, unless they are, my lord, paramedical or allied medical staff. And admittedly, my lord, the tender is for housekeeping and cleaning and scavenging stuff. My lord, I had also in my pleadings, it is there that to page 46 only. Again, now page 46 consists the bullet points.
Yes.
Yes. The last bullet point, undertake any such other duties as may be assigned from time to time by the hospital authorities. My lord, this I have already pleaded, my lord, in paragraph 17, that in view of the wide spectrum of, my lord, duties imposed upon the staff by this, my lord, tender document, what happens is the scope of this clause, my lord, extends to infinity. They can, my lord, make me do anything. In fact, though I have not pleaded this, my lord, but my experience with the other hospital is just the same. They are engaged in computer work also to make data entry.
No, what about you having not taking these points, having not taken these points in your representation? Only 2 points were taken in the representation.
Yes, my lord,
supervisor and something.
Yes, my lord. The 100%, my lord. My lord, I did not push that 100% before your lordship because, my lord, I had this.
100%, yes.
I
Because
already
it is
have
not
more
yet.
than 100%. Now, my lord, it is true that those two were the first things, my lord, that came into notice of the tenderer. Later on, my lord, are points found out, of course, by, my lord, better legally trained minds than the petitioner before your lordships. However, my lord, I most respectfully submit that even if I do not take the point that the tender clauses are illegal, that will not deter the court from interfering in that tender process, despite seeing that it is patently illegal. Well, it is not, my lord, conditional upon taking points. Those representations or those points are for clearing confusion, are for clarifications. These are not in the nature of, my lord, a plaint or a pleading filed in a court, which will bind me, and I cannot go beyond them. Lord, if there is any other point, my lord, because the point of tax has probably not been addressed, the bills inclusive of tax and exclusive of tax has not been addressed by my learned
Tax
other
is
side.
not so crucial in the sense that it could have been thrashed out in the previous meeting also.
Yes, yes.
Could have been.
Yes. And, my lord, this illegal terms, that I am grateful to your lordship, this could not have been, my lord. If they wanted to clear it out, they would have had to come up with a new tender. Even if I would have taken this point, if your lordship is otherwise satisfied that they are illegal point or absurd points or impossible points, my lord, impossible points probably could have been cured, but again, by issuing a corrigendum, which would have then allowed me to participate. Because I could not participate of these terms. It is not that I did not participate by choice, that I don't feel like participating. No, I am engaged in this trade. I already serve in another hospitals with more than 100% capacity. I have pleaded those. And illegality, my lord, this again to clear the tender process of this, they would have at least had to come up with another corrigendum. That has also not been done. And they were aware of this. And, my lord, the specific case, this will be, my lord, my trailing, my lord, submission just to address it. My lord, the case made out is that in the petition, I have specifically said that I was there in the meeting. If, my lord, takes a look at the, my lord, letter dated 7th of January, which was submitted by me, it was submitted by in writing, my lord. And, my lord, on the date when the pre-bid meeting was there, held at the place which it was held. It is apparent from records. And, my lord, I had taken this point specifically that, my lord, my name was not featuring over there. And, my lord, there are other, it has been argued that there are 24 bids which have been, my lord, accepted. Whereas the, my lord, annexure to the signed, my lord.
Bid and there is different thing.
Yes, yes, I understand.
No.
The
Attendance were 18.
Yes, yes.
Yes.
And thereafter,
Inclusive of the officials.
Yes.
But submission of bidders were 24. That is different.
Yes, submissions of bidders were 24, indicating that not all bidders were present in the pre-bid meeting. Maybe, but I was there.
May not be. That is a choice of.
Maybe, may not be. But, my lord, I was there, which will be evidenced by, my lord, the letter which was put in by me on that day at the same place when the pre-bid meeting was, my lord, being held.
How do you ascertain that?
Yes, my lord. Must come to page 85.
I'm there. This received.
Yes. Received by that medical superintendent.
7th of November was the pre-bid meeting date.
Yes, my lord, that will be apparent from the schedule. My lord, at page 27, 7th. And, my lord, it was held at that, my lord, local only of that hospital. That is accepted position. It is quite unimaginable to think that, my lord, I went there, pre-bid meeting was there. I did not go there, I just submitted the paper and came back. And even if I have not submitted,
and you have not signed there in that list.
but I was not given anything to sign. That is my case which have been made out. And Milord, even if it is
in Waka board also, at the top meeting is going on, agenda. And some of the people receiving section is on the ground floor of the Waka board, Lordship, Madam Street. So on that day, suppose some party has some grievance with regard to any of the agenda in the meeting, so not attending there, but dropping one letter in the receiving section. Afterwards coming to the chairman.
May happen.
Afterwards coming to the chairman saying, sir, I have already submitted.
Yes, my lord, let us say that that has happened. And I was not there in the meeting, I just put in my papers. That does not absolve the state respondents from the responsibility of seeing that their NIT is legally compliant and no illegal terms or impossible terms are there.
The arguments are concluded, judgment is reserved. Mr. Galib, I'll try to be as fast as possible because of the other predicament of yours. 31st, the contract is expiring, 31st December. Although we have had cases where previous contract is extended for a limited period and if it is set aside. And if the writ petition is dismissed, then no question of that.
Lordship,
Gratefully, Lordships.
Good argument by both sides.
Lordship.
Great.
Item 7.
Seven, Your Lordship, appear for the petition, Your Lordship. None appears for the bank, Your Lordship.
What should I do today?
Lordship, there is a resolution, Your Lordship.
It will retain its, all these will retain their position.
Lordship,
I'll pick up tomorrow.
in this matter, Your Lordship, affidavits have been exchanged, Your Lordship.
I'll hear it out.
Lordship.
Or should I put it somewhere else?
Lordship.
Under some other heading?
Lordship,
What is the urgency in the matter?
The urgency is that it is a 2020 matter, Your Lordship. In the meantime, I had filed an application which had come up before Your Lordship, and thereafter the matter is appearing today. Your Lordship, the bank has withheld an amount of rupees 20 lakhs on the allegation that it is the ESI and EPF dues, whereas no such process has ever been initiated by the statutory authorities of EPF and
It is not
ESI.
an urgency, Ms. Ghosh.
Lordship, my 20 lakh rupees is withheld by the bank since the year 2020. Lordship, let it retain the position, Your Lordship.
Limit.
Lordship, grateful to Your Lordship.
Not to retain.
My lord, I appear for the petition.
Item 8.
I am appearing for the respondent 6, my lord.
It appeared before your lordships before vacation. Well, my lord has directed my grievances against two banks which are situated in Patna. My lord, banks, I don't know whether banks are appearing or not.
One of them is?
No, my lord, I am appearing for respondent 6.
Respondent number 6.
Who is this? Thou.
My lord,
Only, my lord, there is an order of the Honorable Patna High Court, my lord.
Yes.
May I hand it over?
Please.
in Kunta.
Regarding operation of the bank account.
The same account?
Yes, my lord. Yes, my lord.
This same account?
Yes, my lord.
Nothing. Dekha na order.
Mr. Sinha, if that be so, why should two courts take up? There will be.
I don't know what.
My lord, let me put an affidavit to that effect, my lord. I will
affidavit is required.
Yes, my lord, required.
If I take in affidavit,
because
then...
outsider are occupying the position, my lord.
No, difficulty is your Mr. Please. What is your name, please?
SN Ghosh, my lord.
Mr. Ghosh, if I direct affidavits, then I'll be entertaining the matter.
My lord.
After that, I should not refer it to some other court.
My lord.
I also have to be satisfied whether it is maintainable here at all.
My lord.
Yes, my lord.
Or
Why
it should go
I,
for the partner.
my lord, I do not find any charm in filing writ petition in
No, not
Calcutta,
that, not that.
where the Patna High Court has determination. Patna High Court every time sends me to Calcutta, say that because of a division bench order of Patna High Court, which I have annexed, that all matters relating to that school has to prefer in Calcutta.
What is your cause of action here, Mr. Sinha?
And in a particular suit, my lord,
Let me hear that. Yes. Please take your seat, Mr. Ghosh. I'll just hear it. Yes.
My lord, I am appealing for the Punjab National.
Right.
My lord, 2000, since 2000, the school is situated in Patna. It was initially looked after by a association called Sadnashram Seva Sangsad, which is the respondent number 6, my learned friend is representing, my lord, which is situated in Bidhan Saroni. It's a society for Brahmos, Brahmo Samaj. My lord, there's the only Bengali school in Patna, it's quite famous, Ram Mohan Rai Seminary. My lord, it's being run for long. Shivnath Sastry was the founder. My lord, there's a dispute, internal dispute a suit was initiated in Patna. Patna High Court against that division bench injunction order. Division bench of Patna High Court decided that no, yeah, whatever regarding to that school has to be decided in Calcutta. Since a suit is pending and that suit is still pending in City Civil Court, Calcutta. Thereafter, there are volume of litigations going on between the two associations. One is Bengali Association, Bihar, and another is Ram Mohan Rai Seminary. My lord, two suits in 2022 has been filed in City Civil Court, one by their society, their association, and another by the Patna counterpart. Patna counterpart says that since we are running the association, there should not be any interruption and let there be an order of injunction restraining them to interfering in the matter. Got an order. They have also got an ex parte order that Patna body's order was a contested one. They got an ex parte order of injunction restraining the operation of the bank account. My lord, appeal has been preferred by the Patna Association before the Honorable Court. My lord, Lordship kindly comes straight away to that order.
What is the order you are enjoying, Mr. Sinha?
My lord, I was enjoying no one should interfere in the. My lord, those orders.
In what?
In running of the school.
Very.
Running of the school means I have to operate the bank. My lord,
whose injunction was first?
Their injunction was first, ex parte one. My lord, those two appeals were taken up together by the division bench of Honorable I.P. Mukherjee and my lord, the division bench order is page 186. You got it?
Yes, Mr. Sinha.
Yes. The application can so and so filed in the appeal FMAT so and so is taken up record treating the same as on the day's list. The above two appeals and the stay applications are being disposed of by this composite order. It appears that title suit 301 at the instance of Ram Mohan Rai Seminary, the learned court below passed an ex parte interim order on 5th March 2016 to the following effect, that there will be an ad interim order of injunction restraining the defendant from holding any meeting in relation to the business of the plaintiff Ram Mohan Rai Seminary, but the resolution taken by the said committee is subject to the result of the till 2/4/26 requisite be put. The defendants are so cause within fortnight. Same interim order of injunction granted till this shall not be made absolute till plaintiffs are hereby directed to cause service on injunction application postal receipts. In another suit before the same learned court, title suit number 1439 to 2016, an ex parte interim order was passed to the following effect, that there will be an ad interim order of injunction restraining the defendants and their main agents representatives from distributing day-to-day functioning and administration of the Sandhashram Seva Sangsad as well as Ram Mohan Rai Seminary Patna. Members of Ram Mohan Seminary Patna to the injunction application are permitted to operate bank accounts and investment in accordance with the rules. In the event the cognizable offence is reported, president and the office bearers, so and so. Requisite defendants are so caused within fortnight. Why the mandatory order is granted, till it shall not be made absolute. So,
Mr. Sinha, whereas you were restrained from disturbing the functioning of the holding any meeting regarding, now you obtained an order of injunction that they won't hold any meeting regarding the functioning.
No, my suit is.
Yes, the first order is yours.
My suit is on.
You are Ram Mohan. Title suit 301 of 2016 is your suit.
Yes, yes.
So there you have obtained an order that they won't be holding any meeting relating to business of the school. Yes. And they have obtained an order of injunction that you won't be disturbing Sadhana Seva Sangsad's day-to-day, Sadhanashram Seva Sangsad's day-to-day administration and functioning.
That is Calcutta body.
Yes, as well as Ram Mohan Roy Seminary, Patna. That also you will not disturb.
Yes, and these both the orders were set aside by the order.
But it was observed that members of Ram Mohan Roy Seminary are permitted to operate bank account. You are permitted to operate.
There is a dispute regarding membership of the Ram Mohan Roy Seminary.
They
They
will-
claim they are the members. We claim we are the members.
Very good.
Mana-
What is the ultimate order passed?
While at 190, page 190.
190,
Both the interim orders dated 5th March and 2nd December are set aside. The following interim order is made till the disposal of the interim orders applications by the learned judge. Ram Mohan Roy Seminary will continue to be administered by Mr. Basu's client, that is my client, because Mr. Basu was my leader in that court. Same manner, it was being administered prior to the order dated 5th March 2016. Expenses in the usual course of business only will be incurred by the management. No capital expenditure is to be incurred until further orders. The fixed assets of the seminary will not be sold or otherwise transferred, encumbered, or parted with. We wrote to the bank pursuant to the orders that let me be allowed after the injunction order, bank stopped operation of my account. After this division bench order, we wrote to the bank that day-to-day expenses may be permitted to be operated from those accounts. They did not reply. We went to, we made a representation and we went to Patna High Court. My lord, that is at page.
The bank is situated in Kolkata or Patna?
Patna. Page 199. My lord, Patna High Court, my lord says that in view of division bench order, you please withdraw. My lord, I was asked to withdraw this matter.
What was the division bench order?
Division bench order, my lord, division bench of Patna High Court's order, that is at page 203. The relevant portion is at 204. No one challenged that order. That is the difficulty. After that, everything happens in Calcutta. Good for us, but really Patna is the jurisdiction.
Yes.
But no, since no one has challenged, well,
203.
Well, at page 204, last paragraph. In our view, the City Civil Court, Kolkata, is the competent body to take decision in the matter.
City Civil Court, Kolkata.
Kolkata.
Double T, yes.
Kolkata is the competent body to take decision in the matter. As stated above, there is already an order of status quo in the said case, and settled law is that when the matter is pending before the city civil court and the same interim order has same interim order has been passed, then the other authority should not enter into the controversy, and the case of any controversy or dispute, the matter could be referred to the civil court for adjudication. In that view of the matter, if any parties to the proceeding belonging to the different factions or teaching or non-teaching staffs with regard to any matter wants clarification, they may move before the City Civil Court, Kolkata, in the pending suit, who will pass order and that will bind the parties as well as the state authorities till disposal of the matter. Well, 2016, that is the suit.
That is regarding the orders. If you seek orders in connection with the suit, that will be before the City Civil Court. Now you see an independent cause of action against the bank has not.
That is why I, before filing before the Kolkata High Court, Calcutta High Court, I filed a suit, read petition in Patna.
Oh, that was also.
That was also
in this particular cause of action you had filed
for the bank.
Yes.
Particular cause of action against the bank. Court says that because of the division bench order, you withdraw.
So what is your cause of action? Bank is not honoring this direction of justice.
Bank is not honoring this direction. Let me be allowed. Bank earlier occasion, Mr. Singh appeared, Anuj Singh. He said that he will take instruction. Your lordship take all right. You take instruction, and your lordship also directed me that you show me those orders of Patna High Court.
First I'll hear the bank, then I'll go to respond number 6. Mr. Ghosh, I'll hear you. Yes.
There are two banks, my lord. One is Punjab National Bank and another is Bank of India, my lord. I appear for the Punjab National Bank.
Malad, there are several litigations, Malad, on the basis of a litigation and an order, Malad. The account was frozen, Malad. We did not allow any party to operate that account. Malad, if the records are fine and if that is produced before the bank that there is no status quo, nothing, your lordship, then we have no problem in letting the petitioner to operate that account, whatever falls from your lordship. This is my instruction, your lordship.
Well, let me hear Mr. Ghosh. Yes, Mr. Ghosh, you are for response on 6.
Yes, Malad.
What do you have to say?
The school belongs to Sadhanasam Seva Sangsad. On the basis of fake resolution, my lord, in the year 2001, certain unscrupulous people issued that. We moved the City Civil Court, Calcutta, and obtained a status quo. After that, my lord, Sadhanasam was running the school. The other part, they introduced Bengali Association, the principal who was appointed by Sadhanasam Seva Sangsad. All mischiefs were done by them. My lord, this is a long checkered history, my lord. I have been served 2-3 days, 4 days
Mr.
back.
Ghosh, I have only one question to you.
Yes, my lord. And there is an order of injunction by the Patna High Court in bank regarding bank account dealing, my lord.
Let me have a copy. Have you got an extra copy of
No,
that?
my
Because
lord.
this is a certified copy. For server copy, we can look into.
Just I have able to get it, my lord. Because I have been
So
served.
after Justice Mukherjee's order, has there been any further order? Because this is the last order prevailing. This is a division bench order.
Yes, my lord.
At page 190.
There is no whisper of operation of bank accounts, my lord.
Let us come to that, please. Come to page 190 of that. I'll look into your order, definitely. It starts from page 186.
No, my lord, the operating portion, my
No,
lord.
starts from page 186. Mr. Saptangshu Basu was appearing for the petitioner there. So therefore, Mr. Basu's client means the petitioner there, this petitioner. So now let us come to 190. Ram Mohan Roy Seminary will continue to be administered by Mr. Basu's clients.
Yes, my lord. Only the following interim order is made.
Right.
We'll dispose of the interim order application by the learned judge.
True.
Ram Mohan Roy Seminary will continue to be administered by Mr. Basu's client in the same manner it was being administered prior to dated 5th March 2016. Expenses in usual course of business only will be incurred by the management. No capital expenditure is to be incurred until further orders. The fixed assets of seminary will not be sold.
Very well, we will not bother. B is the one which hits you. Expenses in the usual course of business will be incurred by the management if that is the order of the court. I mean, how can the bank have locus standi to refuse that?
No, they are operating bank accounts, separate bank accounts, my lord. For this long period, they cannot run the school without bank accounts. They are operating. But I need certain time because I don't have the instruction right now.
Now let me look into this order. What does this say? Let us see that. Can you please just place it so that all of us can hear?
Yes,
I mean, both of us can hear. So instead of my reading it
My
by
lord.
myself,
My
you
lord.
just please place it so that all of us can hear.
There are series of litigation between the parties, trying to establish their supremacy over what is known as Ram Mohan Roy Seminary. Here, there are suits pending in City Civil Court, Kolkata. There are some other writ application on this issue relating to who shall continue or who shall be the principal, etc. So long as there is no clear declaration emanating from an appropriate authority with regard to the persons who has a right to run the affairs, no direction can be given to this court by this court, allowing any person to operate the bank account, which is being sought in the present writ application by the present petitioner. Even otherwise, the court has no business to entertain the writ petition application at this stage, in view of the tendency of suits and disputes between the parties in other forums.
Now, Mr. Ghosh, this is a general order.
Gen-
This order
nothing
was
has
not
been
specifically dealt with by that court or placed.
Yes,
Probably it was not placed, obviously.
my injunction is there, my lord.
No,
doesn't-
your injunction has merged into this.
No, my lord. The separate injunction, I can establish, my lord, if my lord can give me certain time, because I have received this 2-3 days or 4 days back, my lord. Although these are filed in 2022.
Yes.
I have just received a few days back, my lord.
There's a change of lawyers, maybe. When I served earlier, affidavit of service has been filed.
Served long back.
No, we have not been served. We have not been served. Only in December we have been served, my lord.
This December, this
yes,
month.
my lord. Yes, my lord.
But this is, first of all, My lord, he
Anyway,
may be
when
a-
do you want to come back? Tell me.
Any day after a week, my lord.
he may be a proper party. He is not a necessary party. My grievance is against the
No, no,
bank.
no.
No, Mr.
Property belongs to
Sinha,
but
there is a dispute between you and his client.
Yes, that's a title dispute.
No, no, my lord.
So if you operate the bank account, if I permit you
I
to
was
operate,
operated and
even then,
Justice
Mr.
Banner,
Sinha, his
Justice
interests will be hurt
Yes,
if you operate the bank
My
account.
lord, division bench order allowed me to operate.
It's an argument you are making, Mr. Sinha. He is entitled to his reply.
All right.
Learned counsel for the petitioner makes out a prima facie case as to the bank being duty bound to permit the petitioner to operate the concerned bank account of the Ram Mohan Roy Seminary, which is an educational institution, pursuant to the order dated December 11, 2017, passed by a division bench of this court in FMAT 1344 of 2016, which is annexed P5 at page 186 of the writ petition, inter alia permitting the Ram Mohan Roy Seminary to continue to be administered by the petitioner and expenses in the usual course of business to be incurred by the management. Full stop. Next para. Learned counsel for the bank submits that the bank has not been permitting operation of the account in view of pendency of several litigations, and it is also agreeable to permit whichever party is directed by this court to operate the same. Push up next para. Learned counsel appearing for the respondent number 6 submits that in view of having been briefed recently in the matter, he seeks some time to take appropriate instructions and address the court. Push up learned counsel for the respondent number 6 also seeks to rely on an order passed by a learned single judge of the Patna High Court of the Patna High Court, which refused to interfere in the matters of operation of bank account in view of pendency of several litigations. Full stop. Next para. In order to enable respondent number 6 to properly contest the matter, the same is adjourned till today. We are on 7th, 8th. I'm sorry, 8th. So please come back on when? 14th? Next Thursday?
15th, Your Lordship.
15th.
14th.
Till December 14, 2023, when it will be placed under the heading upgraded matters. Please come prepared. Mr. Ghosh, please take appropriate instructions. I will also contemplate passing interim orders which may affect your client if I am not satisfied with your. So please come prepared on all aspects of the matter. And justice, this division bench order, whether there has been anything subsequent to override this order. That is important because I am being very candid. I am not satisfied only with this refusal. This does not deal with the issues at all.
That is in the year of 2012, my lord.
May I request Mr. Ghosh to have a copy of that order, Patna?
Oh, yes, yes. Mr. Ghosh, please give a copy to.
I'm sending office
Please do that.
by Monday.
Fair. You can email him also the copy.
My lord.
You can take Mr. Sinha. He is very email savvy.
My lord, made appear as upgraded top.
Upgrade top, not top. If the school is running so long without funds, let it run, continue to run for some more time.
Lawyers' fees are not paid.
Yes. Mr. Ghosh, take care of that also.
Item 9.
9, yes. Not today, brother. Nothing, not today. Resolution is ever.
Item 10.
Yes.
I'm for the petition.
Taking it not today.
Yes.
11.
Same.
12.
There is a resolution. If
Not
your
today.
lordship kindly takes on Tuesday, my lord, Monday, I will be out of station.
That will be an adverse order.
Then my junior will make prayer on Monday. 12 and 13, same matters.
13.
Yes.
14.
Not.
14 will die.
Not. You'll do the matter. You said you'll do.
I'm
You are one of the reasons I am sitting here. Yes, you said.
I'm
Before
saying, Lord, but Vidhannagar Municipal Corporation will pay the amount.
You said you have urgency. You said you'll do the matter after recess.
Urgency in the sense, my lord, the petitioner, the small contractor, he completed all tender works. You're considering
That is the reason I am sitting here.
really grateful, as well as my client also waiting outside. His wife also there. Every day, number of supplier are knocking the
Move
door.
the matter, I'll pass an order.
Without absence, my lord, they will not. Then again, I have to come with the contempt application.
Not-
So let it be remain on the same position. I'm grateful. my lord.
15,
Not today. Not
16,
same.
17, 18, 19, 20, 21,
Okay, the original setting.
Lordship, before my lord takes up original side, item number 32, there is grave urgency, your lordship, very short matter.
21,
32 কালকে টপিক দিদি আপ কালকে টপিক কিছু ফিক্স আছে কাল না মানে সোমবার This will appear fairly at the top of the upgrade
My
matter.
lord, the bank has issued section 13(4) notice under Surface Act. No 13(2) notice has been given to me, and the DM has already passed an
I'll
order.
take up on Monday.
Monday, fairly at the top, lordship, kindly.
Not at the top. At the top, other matters are fixed already.
Lordship.
Immediately after those matters, your matter will be taken up.
Lordship, I am deeply obliged, my lord.
Original side.
Lordship, item number 34, Lord.
Whenever it is taken up.
Actually, Lordship, in this matter, Lordship, I have some urgency, Lordship, so kindly give an indulgence because
No.
the petitioner is the citizen of Pakistan.
Pakistan. That is very lucrative, but
Lordship,
take up in due course. Yes.
Original side matters. Review application, item number 1, Shopon Kumar Dotto.
Not today.
Item number 2, MKN Investment Private Limited, and another.
All three not today.
Item number 4, court application, Sanjay Prakash Bansal, and
Same.
5.
Same.
Item number 6, secure print. Item number 7, item number 8, item number 9, item number 10, item number 11, item number 12, item number 13, item number 14, item number 15, item number 16, item number 17, item number 18, item number 19, item number 20, item number 21.
Start the matter. No, start the matter. Then not today.
It's a grave urgency.
Grave urgency, pass over thale.
Item number 22, item number 23, item number 24, item number 25, item number 26, item number 27, item number 28, item number 29, item number 30 for hearing, item number 31, item number 32, item number 33.
For the petitioners, my lords, this matter, your lordship had directed us to file written notes. We had submitted, the other side is yet to submit. I was only praying, I know, my lords, it's top, but no day the matter is being taken up. I was only praying for time may be fixed at 3 or 3:30. Initially on 30th November, your lordship had fixed the time. But thereafter,
Any further oral hearing was left?
Yes, the other side.
Then what can be done?
Kindly, my lords, if any.
No, what can be done? I mean, I don't understand. Because if it was only for filing of written notes, I could have put it as to be mentioned. But if there is hearing to be done, but the
There is
hearing is to be done by them.
Yeah, they are left with a bit of portion. If only a time, because 30th November, my lords had fixed a time. Thereafter, when the matter had come up, your lordship had directed that we file the preliminary notes first and then proceed with the hearing. I would intimate the other side.
They will inform him this will appear at 3 p.m. on 19th December. 19th December 3. একটা order record করে নিতে হবে. When the matter is called on for hearing, you are for the petitioner.
Petitioner.
When the matter is called on for hearing, the petitioner is represented through counsel, although none appears for the respondents. Full stop. Learned counsel for the petitioner submits that the petitioner is prepared with his written notes of arguments and has concluded its oral arguments. Full stop. However, comma, the matter only remains for hearing the respondents and filing of written notes. Full stop. Next para. Hence, on the prayer of the petitioner, the matter is fixed to be taken up at 3 p.m. on December 19, 2023.
My lords. Also, my lords, our reply is set to be given. I mean that, yeah.
Item number 34, item number 35, item number 36, item number 37, item number 38, item number 39, item number 40, item number 41, item number 42, item number 43, item number 44, item number 45, item number 46, item number 47, item number 48, item number 49, item number 50, item number 51, item number 52, item number 53, item number 54, specially assigned matter, item number 55, item number 56.
Very unfortunately and practically, I submission before this honorable court, my lord, appellate side matter 96, my lord. The
21.
The early occasion, my lord, the honorable court 18 September 2023, my lord, passed the order that, my lord, till
I'm
dispose of.
not taking up appellate side. When
My
the
lord,
appellate side is called on,
this is very urgent matter, my lord, my lord.
even
That is-
then,
That is why, my lord.
no.
My lord, my lord,
I'm taking up original side matters.
yes, my lord.
Please call on the
Item
passport.
number
matter.
21, Passover matter, Arabul Islam and others versus Union of India and others.
Not today. Yes. Senior বোধহয় রাজি হয়নি আর।
But very urgent matter, my lord, appellate side.